Not application.
Application, yes.
Restoration application
Yes.
of railway claim application has been dismissed. That restoration.
Sub copy upon the other side.
Yes, already it has been served.
Okay.
Lordship, may I permitted to mention for inclusion?
It is not this is the second time.
Yes.
Lordship, may I permitted to mention for inclusion this insurance matter? This matter was supposed to be come on 20th February 2025.
We are ready for hearing matter.
Lordship,
Yes. To be mentioned.
grateful Lordship.
Yes.
My lord, this is for inclusion, my lord. MSCC matter.
Hearing matter.
Yes, my lord.
Yes. To be mentioned.
My lord, may I be permitted to mention one second matter for extension of
Yes.
My lord, may I be permitted to mention one injunction application has been filed in connection with second appeal number 86 of 2023. The respondents are trying to alienate and sell the suit property to a third party.
The appeal is already admitted.
Yes, madam.
Yes. Give it.
Hearing under 163A.
Hearing. Okay. To be mentioned.
Your Lordship, with your kindly, may I mention a matter for inclusion in the list? Your Lordship, this matter had appeared last on 12th December, and the appellant, I appear for the respondent, and I am mentioning upon notice. Your Lordship, a direction was passed upon the appellant to give the entire deposit amount before
Okay.
the,
Let it appear as to be mentioned.
Yes, Your
Sub notice.
before the notice has been given.
Give it. It will appear as to be mentioned.
Extension of interim order from the list and determination of Honorable Justice 2033.
Yes.
May I permit to mention, Your Lordship, one application for extension of interim order.
The second appeal.
First appeal, Your Lordship.
First appeal for extension of.
Interim order.
Yes. Give it to be mentioned.
May I have my lord's time? The list stay applications, my lord.
Yes.
Correction.
Correction. Yes. To be mentioned.
Lordship, may I permit to mention one second appeal hearing matter? Already last
Which year?
2021.
Okay. Give it to be mentioned.
Yes, it was mentioned, my lord. So the application for stay already appeal admitted and stay already continued. But I am only praying for paper book and
Okay. To be mentioned.
already file is lying there. But
It will appear as to be mentioned.
file line পড়ে আছে পরে এসে দেখুন পেপার বুকের অর্ডার আছে এই দেখো পেপার বুকের অর্ডার আছে
Can
You are for the appellant.
I'm not the applicant. Can 12367 old can number is the application. 12367.
Yes.
The application, my client has already deposited the entire average sum together with interest. Kindly dispose of the stay application and stay to be made absolute.
মানে kindly 1, 2, 3 application is disposed. 4 is the amendment of the বাকিগুলো আমার কাছে নেই
No. Stay application is disposed.
ডিসপোজ হয়ে গেল তাকে এদের এখানে কোনো কিছু নেই বলি
This is Can 1 of 2014.
ছিল
Yes, my lord.
This is what?
নতুন না সবই
40?
ওল্ড সবই ওল্ড আমাদের নম্বর আছে 1, 2, 3, 4
Anyway, you have already deposited.
Yes.
That is entire awarded sum.
Yes, my lord.
That is 4,18,500.
Yes, my lord.
When was the date of deposit? 4/6/2015.
2015.
15.
15.
So obviously it is disposed of. This section, the stay application.
If it is not disposed of, kindly dispose of that application.
interest not deposited awarded 4,43,500 along with 7% default 9% interest from the date of
Where
filing
is
the
that
application.
order directing to deposit? Let me see that order.
No, ওর তাহলে স্টেটাই ইয়ে হয়ে যাবে না তো, জমা দাও নি তো, কত টাকা জমা দিয়েছো তুমি দেখো না।
4,18,000 and 25.
তুমি বলে দাও পরে ইয়ে হলে adjust করে, সেটা বলো। 4,43,500 allocating interest.
ইন্টারেস্টের অর্ডার ছিল না মনে হয়।
হ্যাঁ এই তো দেখো না নিচে, ও
কোথায় হলো?
মানে হাইকোর্টে
Yes, there was a direction on 14/5/2015 that the appellant is directed to deposit the balance award money less statutory deposit. So have you done that?
Yes, my lord.
ও আচ্ছা,
Yes.
You have deposited only the principal amount.
Principal
What was the awarded sum?
4,43,500. There was no direction for the deposit of interest.
So 4,18,500 you have deposited.
Yes, plus 25,000.
Anyway, there was a condition that if you deposit the same, it will continue till further orders.
Yes.
So there is a stay.
Yes. Intent stay, my lord, kindly dispose of the stay application and stay to be made absolute.
Yes.
তারপরে এটা বলছি।
Learned advocates for the parties are present. The
2-3 মনে হচ্ছে আমাদের
order of stay of the judgment and award passed by the
তার মানে
বলছি
না এই
judgment and award
উইথড্র করে নিচ্ছি,
dated
এটা আমার অ্যাপ্লিকেশন
থাকবে। এই 750 4 নম্বরটা আমার।
4 নম্বরটা ঠিক আছে।
31st October 2014, passed by the learned additional district judge, redesignated court Paschim Medinipur in MSC case number 11 of 2011
শুধু only deposit the award
shall remain stayed till disposal of the appeal.
My lord,
So are the paper books ready?
my lord, another application is there, my lord, that is, my lord, can 4 of 2017.
What is that?
That is old can 750 of 2017.
Can 4.
Can 4, new can 4 of 2017. Old can is, my lord, 750 of 2017.
দেখুন তো আছে কোথায়?
Old can 750.
করে নিয়েছে কোথায় রে?
এটা কোথা থেকে এলো? পুরুলিয়ার ইয়ে রেকর্ড 700 আগে কান্টা ডিসপোজাল
Old can is, my lord,
750.
750, my lord. Here, my lord, I have my lord, filed this application for amendment of cost title, my lord. Your lordship kindly come to, my lord. Paragraph 5.
Paragraph?
Paragraph 5.
Yes.
5 of application. The petitioner states that proposed amendment of cost title are as follows. Well, inadvertently, some other person has been already included in the memo of appeal that respondent number 7.
So were they parties to the,
No, my lord, because
so 3 to 7 were not parties in the, before the trial court?
yes, my lord, deleted. That may be deleted.
Yes, record and order, learned advocates for the parties are present. The application for amendment of cost title is taken up for consideration, being can 750 of 2017. Hard learned advocates.
এটাই তো আছে।
It is submitted that respondent number 4, 5, 6 and 7 were impleaded due by mistake and they were not parties before the learned trial court. Thus, this application stands allowed. Let the names of respondent number 4, 5, 6
3,
and
4, 5, 3.
3, 4, 5, 6 and 7 be deleted from the cost title.
And another pair, my lord.
Yes.
Kindly, my lord, respondent number, my lord, 8,
Yes,
mentioned in the memo of appeal,
yes.
that name also been wrongly recorded. My lord, your lordship find paragraph 5, your lordship will find paragraph 5. Instead of respondent number 8, namely Raghunath Mukherjee residing at Bhagavan Bhagwandapur, Purulia, Prince such and such, owner and respondent. Sri Purnachandra Shashmal, son of such and such, be malad substituted.
Yes, and instead of respondent number 8 Raghunath Mukherjee, the name of Sri Purno Chandra Shashmal as mentioned in paragraph 5 to the petition be impleted. Let the amendment be carried out within 2 weeks. Let this matter appear on
Another two applications, they are malad filed that withdrawal of malad some amount.
Okay, let that be kept
Yes.
pending. Okay, let the amendment be carried out within 2 weeks. Liberty to mention thereafter. So after the amendments are carried out, you mention.
My lord.
File the department now.
Item number 5, I beg to appear for the my lord. On the last yesterday, my lord, I could not assist your lordship. Paper books are yet to file, my lord. May I be permitted to file the paper books? I find it is lying ready, actually ready. What
For the respondent.
is for the respondent? I have served the copy of.
On a learned advocate, what is appearing on behalf of the given in this one? Only
Has
what?
to be fixed for hearing. Yes, record an order. Learned advocates for the parties are present. As the appeal is ready for hearing and the paper books are being filed today, let the paper books be kept with the record. List this appeal for hearing on 27 তারিখে দেখুন তো কোনো ইয়ে আছে কিনা 27 তারিখে 2টোর সময়
কিন্তু বলেছিল ফেব্রুয়ারিতে করতে হবে।
হ্যাঁ 2টোর সময়
My lord, kindly make it in the month of February, my lord.
আচ্ছা 2 তারিখে দেখুন তো ফেব্রুয়ারি 2 তারিখে 2 তারিখে 2টোর সময়
Not to do with
Yes, 2nd February 2026 at 2 p.m. Yes, item 6, not today.
May it please your lordship, whether this is my appeal and there are two applications listed before your lordship today. I am for the appellant petitioner.
Lordship, I appear on behalf of the respondent. I'm led by my senior. Skip him with time.
Two applications are there.
Two applications are there, my lord. Today it has come under the heading to be mentioned.
No, these applications are to be disposed.
Yes, these have to be heard, my lord. One is, my lord, an application for stay. Initially, an order of stay was passed in my favor. That was valid till 31st July. Thereafter, my lord, I filed an application for extension of the stay, my lord. That is the other can which is pending, can 6. So, my lord, both these applications will have to be heard. Today it is under to be mentioned, my lord.
So let the appeal be heard out.
Yes, I do not join issues with that. Only issue is when they are enjoying the property for free. The Honorable Division Bench, while admitting the appeal and framing the questions of law, had kept the point of occupational charges open for the Honorable Single Bench, which to be decided.
That is right.
So, my lord, that issue possibly has to be heard first, perhaps.
Have you taken out any?
We have filed an affidavit in opposition to their application for stay.
And we have filed an affidavit in reply. And a copy has been served.
So let this application along with this occupation charges issue be heard out.
Yes, yes, no difficulty there, my lord.
Either this week or in the coming week.
I think coming week will be more appropriate, my lord, subject to your lordship's convenience and diary.
Opposition reply আছে reply নেই বোধহয়
ঠিক এই রিপ্লাইটা সার্ভ করিনি করেছো তো
স্যার মেল নাকি হার্ড কপি একটা কপি দিয়ে দেবে
My lord, any date, my lord, next week, my lord, we'll come back, my lord, so far as the
Learned advocates for the parties are present. Let this applications can 1, can 4 of 2025 and can 6 of 2025 be listed under the heading application on,
Could it be 22nd January, subject to your lordship's convenience?
just a minute.
Or 23rd? No, 23rd is a holiday.
Yes, 22nd, do you have any difficulty? 22 1 2026 at in 2 p.m.
We will come back at 2 p.m. I'm grateful.
22 तारीख fix আছে 2 p.m.
Let it remain in the list, but we'll take a chance, my lord. Let
Anyway,
it appear normally, yes.
Let it come under the heading
Yes,
Under the heading?
application.
Well, let it retain its position, my lord, because
anyway, no, not to be mentioned under the heading application.
but let it be on the slightly towards the top. Otherwise, we've been under pressure to get this matter heard. It's a legal aid matter also, and the execution is again coming up before the trial court.
When is the next date fixed?
23rd February.
23rd February.
There is some time, yes.
Okay, 22/1/2026. Okay, let it retain.
In case it doesn't,
its position.
in case it doesn't get taken up, my lord, kindly permit me to mention it so that a time may be
Let
fixed.
it appear
thereafter.
under the
Yes,
heading
yes.
application.
Very well.
I'm so grateful.
I'm grateful.
My lord, I am for the appellant. My lord, kindly see paper book page 10 and 11.
Yes.
This is for the insurance company. 10 and 11, my lord.
So the matter is ready for hearing.
Ready? Ready.
So let it appear tomorrow or day after tomorrow for hearing. Yes, learned advocates for the parties are present. As the matter is ready for hearing and the paper books are filed, let this matter appear for hearing on 19/1/2026 within first 10 matters.
My lord, one thing, name of the advocate may be changed. File separate Bhokaradhanama.
You have filed it in the department.
The Bhokaradhanama already in. No, already filed.
Already filed. Anyway, your name will be recorded.
Only check.
My lord, in this case, I am appearing on the respondent claimant. Mrs. Pal is appearing on with the appellant, my lord. Paper book has been filed, all the formalities has been completed.
I don't know.
Yes. Yes, the matter is ready for hearing.
Yes, my lord will fix it up for hearing.
Learned advocates for the parties are present. As the matter is ready for hearing and the paper books are filed, let this matter appear for hearing on 27/1/2026.
27/1, my lord. Thank you. Well, my lord, yesterday my lord was kind enough to make it not today, not tomorrow, and fix it up tomorrow, that is on 15th.
Okay, let it be not today then.
Not today, huh?
Grateful.
All right. But in my lord, short pass over only.
Pass over.
The matter has already been settled between the parties. Let the advocate come.
14, my lord will kindly make it not today, my lord.
Not today.
Grateful.
Yes, item 16.
There's a direction for filing Talabana and notice of appeal upon the respondents. For the department, I have complied with the order, such order, and we are awaiting for the report of the department. Whether
Trial
the,
court records have come.
no, Malad. That has not been called for. Malad, kindly call for the trial court record also, Malad.
Yes,
Kindly-
record an order. Learned advocate for the appellant is present. The trial court's records be called for at the special messenger cost.
Usual course. Usual course.
Okay, the trial court's records be called for. Let this matter appear on 29/1/2026.
Or Malad, kindly, Malad, for the timing, kindly make the matter go out of list after the effect of service upon the respondent and also the arrival of LCR, I shall.
Yeah, I'm keeping it in the month of February then. Let this matter appear on 2/1/2026.
2/2.
My lord, in item number 17, my lord, I am appearing on behalf of the appellant insurance company. My lord, this matter is coming up for the first time, my lord. I have already deposited, my lord, 25,000, my lord, statutory amount.
Yes. Record an order. A file din. Yes. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 19th September 2025, passed by Learned Additional District Judge, 7th Court, Paschim Medinipur, in MSC case number 31 of 2022 for a period of 5 weeks. Stop. The appellant insurance company is directed to pay the entire awarded sum along with interest, excluding the statutory amount, within the period of 5 weeks. Stop. In the event such deposit is made within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. The Registrar General, High Court, Calcutta, is requested to invest the deposit in a fixed deposit of a nationalized bank and renew the same from time to time. Liberty to mention.
My lord, Passover matter already both sides represent.
Yes. Yes, call the Passover matter.
13. Item number 13.
Yes, 13.
My lord, both any petition.
Parties have agreed to a total amount. Now, the entire amount that has been deposited by the insurance company is 21 lakhs and 20 lakhs. 21 lakhs and odd. The parties have agreed that the claimants will withdraw a total amount of 18 lakhs from that, and the
as a full and final settlement.
Full and final settlement.
And the residual amount, along with the interest that has been accrued from the date when it was deposited, will go back to the insurance.
Have you entered into a terms of settlement?
Yes.
Yes.
The petition to that effect.
So let me see.
My lord, subject to payment within a stipulated time.
That means you have to withdraw. You have to withdraw the same after compliance of all requisite formalities.
Yes.
There is no question of payment because the entire amount is already there. They have to withdraw.
Liberty may be given.
Have you filed a petition with regard to the terms of settlement? Yes. What is the case number, application number? Terms of settlement.
Can 1, 2, 3, 3 আছে তো? No. 3. অ্যাপ্লিকেশন নাম্বারটা কোথায়? আমার কাছে নেই। হ্যাঁ? তাই হবে তাহলে। হ্যাঁ, ওই তো আছে। অভিজিৎ, ক্যানটা বিক্রমাদিত্য না রেকর্ডে নেই। আচ্ছা।
So you are representing respondent number 1, 2, 3, and 4.
No.
He is only one.
Okay, just a minute.
Yes.
This is ICAI Lombard versus.
I am for the
Okay, one.
He is only one.
There is only one claimant.
Yes.
The other three, my lord, one is the insurance company, Bajaj Alliance. They have already
Satisfied the award.
the amount of their part of the award. As far as 2 and 4 are concerned, they are the owners of it.
Oh, 2 and 4 are the owners
Yes,
of the
yes.
vehicle. So number 1 is the claimant.
It's an injury case.
Okay. This is, let me see the terms of settlement.
বুঝেছি ঠিক তাই লেখা আছে দিয়ে দেবো একটা ওতে আমাদের কাছে কপি আছে তো দিয়ে দিই পেয়েছি ঠিক আছে
Where is that annexed? You have stated copy of the letter is annexed, but it is not yet annexed.
My lord, I have forgotten to do. This is the letter, my lord.
This is affirmed. This petition is affirmed.
Affirmed,
petition.
affirmed.
You have not annexed.
দিয়েছি
Yes, record an order. Yes, can 5. Yes, for insurance company, who is signing this?
Signed by the legal manager.
No official seal is given.
The affidavit is also by
Affidavit is by?
the legal manager, Indrajit.
দাস নাকি
Yes, learned advocate for the appellant, ICICI Lombard General Insurance Company Limited, and learned advocate for respondent number 1, claimant, Vikramaditya Ghosh are present. It is submitted by the learned advocates that during pendency of this appeal, the appellant and respondent number 1 have entered into terms of settlement.
বলে দিয়ে দেবে
Stop. It is further submitted that
উল্টো হয়েছে এখন মাথার
this appeal was preferred by ICICI Lombard General Insurance Company Limited
আমি জানি
against the judgment and award dated
The 20th of February 2023.
20th of February 2023, passed by learned additional district judge, learned additional district judge,
13th court
13th court Alipur in MACC 31 of 2019.
right
Stop. The appellant ICICI Lombard and the respondent number 1 have entered into a terms of settlement and have filed the joint compromise petition duly signed by the respondent number 1 as well as the legal manager of the appellant insurance company. The copy of the offer letter issued by the appellant insurance company to respondent number 1 dated 19/12/2025 is also furnished. Upon perusing the terms of compromise and upon hearing the learned advocates, this court finds that the said compromise is entered into in accordance with law and in the interest of justice, the same should be allowed. Thus, this application for compromise being Can 5 of 2026 stands allowed. Accordingly, the respondent number 1, Bikramaditya Ghosh, is permitted to withdraw rupees 18 lakh, which is the amount settled by the parties fully and finally. The respondent number 1 may, upon compliance of all requisite formalities, withdraw rupees 18 lakh deposited by the appellant ICICI Lombard General Insurance Company Limited. Stop. The residuary amount of the deposit along with the accrued interest be returned to the appellant ICICI Lombard General Insurance Company Limited. Both Can 5 of 2026 along with the appeal FMA number 489 of 2023 stands disposed in accordance with the terms of compromise. Yes, next.
I'm for the appellant insurance company, Lordship. This matter has come up for the first time. I have deposited the statutory amount. Can 1 is for the stay application. It is filed within time, Lord.
Yes.
Dada.
Yes, record and order. Learned advocate for the appellant insurance company is present. Stop. As the appellant insurance company has deposited the entire awarded sum as deposited the statutory amount of rupees 25,000. The judgment and award dated 4/11/2025 passed by learned additional district judge, 3rd Court Sodor Poschim Medinipur in MSC case number 229 of 2016 shall remain stayed for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest, excluding the statutory amount, within 5 weeks. Stop. In the event such deposit is made within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Yes, liberty to mention. আচ্ছা ওইটা করে দেবেন. The Registrar General is requested.
For the respondents, my lord. It is not.
I pay for the appellant, my lord. যখন প্রথমে হাইলাইটিং তখন ওইটার উপর অ্যাপ্রোপ্রিয়েট অর্ডার স্টে পেয়েছিল তুমি এটা করবেন তো ক্যান টু মিলট it is the application for substitution মিলট respondent number 1, 7 and 9 has died মিলট can 2
and can 1 is the continuation of delay.
No milord, can 1 milord was filed initially with the memorandum of appeal. It is for stay.
Has the appeal been admitted?
Yes. Milord, in the year 2018, milord, the appeal has been admitted.
Okay, this is for substitution of respondent number
1, 7 and 9. Milord, your lordship will find, milord, the details of the legal age of the respondents, milord. We have mentioned, milord, in milord, paragraph 3.
3, my lord, is with regard to respondent number 1. 4, my lord, with regard to respondent number 7. And 5, my lord, with regard to respondent number 9.
Okay, when did this respondent die?
My lord, the respondent number 1, my lord, died, my lord, 1st February 2020.
And the other respondent?
My lord, respondent number 7 died, my lord, 22nd April 2023. And my lord, the respondent number 7, my lord, 9 died, my lord, 3rd October 2023.
Yes, what is the ground for delay?
My lord, delay, my lord, as such, my lord, there is no
So,
leading, my lord, your lordship will find.
so neither you have prayed for condonation of delay,
Yes,
neither
yes, we have prayed. My lord, paragraph 8, my lord. Lord, as soon as we came to know about this death, my lord, this, my lord.
where have you stated when you came to know?
My lord, page, paragraph 7, my lord, page 70.
Paragraph 7.
Lordship. Specifically, my lord, it is not
Where
mentioned.
have
My
you
lord,
stated that you have come to know about the date of death?
my lord, that has not been, my lord, mentioned, my lord.
Yes, who is for the respondent? Yes.
I'm for the respondents, my lord.
Yes.
My lord, no, here, my lord, ground for delay is mentioned here, my lord. Only that is my submission. Other than nothing.
My lord, paragraph 8, my lord, we have mentioned the delay.
No, but what is the ground for your delay?
My lord, then, my lord, your lordship.
Yes, record an order. Learned advocates for the parties are present. Hard learned advocates for the parties. This is an application for substitution filed for recording the death of respondent number 1, 7, and 9. The petitioner has in paragraph 3, paragraph 4, and paragraph 5 of the petition for substitution mentioned the names of the legal heirs who are to be substituted in place of respondent number 1, 7, and 9. Upon hearing the learned advocates and considering the facts of the case, although there is delay in filing this application, which the applicant has prayed for condonation, in the interest of justice, such delay is condoned and the application for substitution is allowed. Let the names of respondent number 1, 7, and 8,
9.
1, 7, and 9 be deleted from the cause title, and the years as mentioned in paragraph 3, 4, and 5 of the petition be substituted in their place and state. The amendment be carried out within a period of 2 weeks. Liberty to mention.
Grateful to my Let the affidavit of services.
The affidavit of service file be kept with the record.
Grateful. My lord, I'm appearing for the appellant. My lord, I have filed this appeal. In the appeal, there are 4 defects. It was not previously seen, my lord. On the last day of your lordship's order, I should have to pay the rest of the court fees. I have already paid, and it has already been deposited before the learned Department, my lord.
The appeal is not yet admitted.
My lord, appeal has already been admitted.
Already been admitted.
My lord, in the meanwhile, they already filed an
Okay,
execution.
there was a direction to pay the deficit court fees.
My lord, that has already been
That has been
paid.
done.
And my lord, there are another two defect. First, the decree has not yet been prepared. My lord, kindly go through the defect once, my lord. And second is trial court decree is illegible. হ্যাঁ না হলে আমি কিছু করতে পারবো না এখানে আর ডিগ্রি তৈরি হয়নি আমি দেবো কি করে
You have also seen the defects.
My lord, I have also seen. My lord, first was that that appeal has not certified of the degree of the appeal has not yet been
That is
prepared.
another issue. Yes, regarding the execution of the Vokalatnama.
My lord, Vokalatnama, the appellant number 1 was there. The appellant number 1 has already died, and we have already filed an application for substitution. And along with that, we have also filed the Vokalatnama of all others appellant and would be appellant.
You see, the names of the defendants number 3, 4, and 6 in the decree of the trial court differs.
My lord, it is thereafter, my lord, kindly see that are illegible in some parts. As it is illegible, all the names has not been written. My lord, it should be the decrees for drawn of degree. The record should be returned back to the learned court below so that the degree could be drawn. Appeal court degree has not yet been drawn.
Copy of the decree on appeal has not been filed.
My lord, as it has not been drawn, I have not been able to get the decree. But as the execution being in proceeding, so I have to mention this matter before the division bench, and already it has been admitted.
Yes, record and order. Learned advocate for the appellant is present. The appellant has paid the court fees in terms of earlier directions. Let the copy file be kept with the record. As the degree of the appellate court is not drawn up, the same may be drawn up and handed over to the appellant upon compliance of all the necessary formalities. With regard to the trial court, the same may be sent by the department to the learned trial court for necessary corrections in the names of the parties to the suit.
And my lord, my application for substitution is number 5.
So let this correction be made.
Correction.
Thereafter, the substitution application will be taken up.
My lord.
So the matter is sent to the trial court so that the decree can be
drawn up.
No, decree can be rectified with regard to the parties to the suit, okay?
And
the appellate court decree be drawn up and handed
lord.
over to you
My lord,
on compliance of
My
the
lord,
formalities. It has to be handed over to you
Either that I cannot file,
because after you collect, you have to file it.
my lord,
And so far the trial court is concerned, it has to be sent back
my lord,
for necessary rectification
lord.
in the cost title.
my lord. And my lord, stay may be granted a long period because the time that would taken for
So
the
when is the next date fixed?
next Friday.
Achha. Pending hearing of this appeal, there shall be stay of the execution proceedings for a period of 6 weeks or till further orders, whichever is earlier.
My lord, kindly fix the matter, my lord, unless that it would not appear.
No, liberty to mention.
Liberty to mention, my lord. Oblige. হ্যাঁ দিন না আপনি অভিষেক ব্যানার্জি আচ্ছা আমি দিয়ে দিচ্ছি oblige, my lord.
The item number 21, my lord, this is that matter. My lord, the lordship may recall, my lord, in my suit, my lord, I filed an application for injunction restraining the other side from not to disturb my position and not to alienate. This was a suit for declaration, my lord. In declaration, declaration for a scheduled property and recovery of position of B scheduled property. And my
There
lord,
was a report was obtained regarding the position.
position, my lord, if your lordship kindly see the special officer report, the special officer has found that in respect of the
My lord, respondent number 1 died.
maybe.
My lord,
In the meantime, my lord, possession has been held in our favor, my lord. The appellant is possession in respect of 137. And if your lordship kindly takes up the report, my lord, the respond number from page number 2.
এই এটা খুলে দিন তো রিপোর্টটা।
Pursuant the direction passed by your lordship on 12th of December, my lord, your lordship directed to ascertain the status of the parties and the position in respect of the parties in the suit. Kindly, my lord, skip paragraph.
Yes, record an order.
my lord, kindly hear me regarding report, my lord. My lord, kindly see the page number 6. Page number 6, that is your lordship's order.
Page number
Lordship
6.
directed to take the picture and a map about possession of the respective parties.
Yes.
Malab, only picture and the respective possession of the respective parties.
Yes.
Manda in the map, my lord, I do not know where from.
Well, he has not taken any exception to the report.
Yes.
I will. Malad, I will file.
In the meantime, my lord, can you status?
No, my lord. What happened, my lord?
Each and every time, my lord, he's taking up a plea, and my lord, he's trying to stall.
You want to take an exception to the report?
Yes, my lord. Kindly see the appellate. What happened, my lord? Report says that, my lord. Report says that as per surveyor record, my lord. What is the record? Record has not been produced before your lordship.
Yes,
Page 3.
The map has been produced. My lord, map has been
Page
produced.
3, my lord.
My lord, what he is saying, my lord, he has not gone through the report, my lord.
My lord,
Can you
yes,
see the
Record an order, please.
Page 2 of the report.
Advocates for the parties are present. Mr. Dash, appearing for the respondent, prays for leave to take exception to the report of the special officer. I have gone through the report of the special officer with regard to the position.
Yes.
However, an opportunity is granted to Mr. Dash to take exception to the report. In the meantime, there shall be a status quo with regard to the possession of the suit property.
My lord, what
For a
happened?
period of 5 weeks.
My lord, what happened, my lord? My construction will be stalled. This is a Pradhan Mantri Awas Yojana. My lord, kindly see the.
I have gone through the report. I am satisfied. You want to take an exception, please.
No, my lord. Regarding my construction, this is Pradhan Mantri Awas Yojana.
It is
My lord,
constructed.
my lord, kindly see the page 2 of the report.
It is a constructed.
After you submit this exception,
Yes, it will be.
My lord,
upon considering the exception, if I find that your construction is necessary, the position will not.
my lord, this is the scheme of the.
No, definitely you will continue with your construction. You first take an exception. Thereafter you continue with your construction. Yes, let this matter appear on Yes, let this, I'm keeping it, how many weeks you require for filing exception?
Within 2 weeks, my lord.
Let this matter appear on 29/1/2026.
I think make it on first week of February.
20
affidavit,
the 29/1/2026, the exceptions and the oppositions shall be filed in the meantime.
Well, 29, kindly do not take it up. Kindly take it on first week of February.
No, then my lord, after 12, my lord, I have some problem. After 12 February. If January, okay, my lord, if February, my lord, after 12th of February.
Okay, 16/2/2026.
Stay for 5 weeks.
Whatever it is, yes, 5 weeks. In the meantime, exception and affidavits should be
My lord,
completed.
and construction will be stalled. That's why, my lord.
No.
This is the Pradhan Mantri Awas Yojana scheme. As per scheme, I am constructing. They have nothing, my lord. This is the vacant land. Report has been said that this is a vacant land.
So in that land you will construct.
No. As per scheme, there is 2 land. One is vacant. I have construction in another land.
No. You come with an exception. Okay.
My
If
lord,
I
he has
find that,
already
if I
constructed.
find your construction is necessary, I'll modify that.
My lord, he has already constructed.
My lord, I'm appearing on behalf of the petition. I'm led by Mr. Shoradipto Banerjee. He's on the way. Kindly give me a short passover.
For the appellant.
Petitioner.
So the respondent numbers 1 to 3.
Not today.
Appellant.
Milord, kindly hears this matter, Milord. She's
We are ready, my
Passover,
lord.
Milord.
No,
We are
she
also
wants a
ready.
Passover, I'm making it not today. Because I don't know after Passover whether I'll be able to take it up or not. Anyway, I'm passing it over. If both of you are present, you mention.
Grateful, Milord.
Grateful.
My lord, I'm for the petitioner. My lord, the service has not been completed. Kindly.
Okay,
adjourn
not
the
this
matter for
week.
1 week. Yes. Thank you.
24 I appear for the petitioner that I am filing, my lord, the oppositions, my lord, in the can 1 and can 2. My lord, what happens is that, my lord, pursuant to your lordship's earlier order.
My lord, they have served upon me on, my lord, January 6. I will take 1 week time or 2 weeks time. I shall file the
That I have
opposition.
no
Which
objection.
application? Can?
My lord, can 1 and can 2.
Can 1 is for?
My lord, can 1 is an application for stay of the execution. Can 2 is another application for stay of the execution since the interim order was vacated in view of the caveat being filed by us. But can 2 is not maintainable.
Anyhow, my lord, there is an interim order, my lord. 2 weeks time, I'll file opposition. They have served only on.
Okay, let this matter.
Lord, one more submission. Lord, kindly takes the last order once.
Yes. No, he's not ready. He wants to.
Lord, as per the last order, Lord, your lordships has directed to pay rupees 5,000 as occupational charges.
Yes, they are paying. They are paying.
Lord, they are paying. Lord, they are not paying the area occupational charges.
They are paying.
They have not paid, then it has
They
to
are
be
paying.
vacated.
In the morning.
Kindly seize the order.
Yes.
What do you know? How much have you paid? Let me see the order.
Only from the date of the order they are paying.
They are paying 5,000.
Lord, we have served a letter. Lord, kindly.
Yes, I have received. I have said that you pay.
Let me see the order.
Kindly seize the order. 8th of December 2025.
The applicant go on paying rupees 5,000 as the monthly. They are paying.
Oh, which you were paying before the first appellate court till further orders.
Yes.
When did you pay last?
Lord,
When did you pay?
Last, my lord, after.
No.
Before
May the
2024. May 2024, Lord, they have paid last.
They have paid last.
And they are paying from December 2025. Lord, in between that period, Lord, nothing has been paid. Lord, we have served the letter to that effect. Lord,
Yes, I have received your letter. I have not denied.
So areas you have not paid. You are paying this current rate.
Yes. So I asked them.
How much is due and payable?
Lord, 90,000.
90,000.
My lord, she's a
Give him
poor
some
man.
chance to pay by installment.
Yes, they are
paying.
But they should pay.
Yes, they are.
They got an order.
Yes, I have said that they should pay.
Learned advocates for the parties are present. It is submitted by the learned advocate for the respondent that the appellant is paying the occupational charges of rupees 5,000 from the date of the order, but the area occupational charges, which is to be paid from May 2024 is not yet paid, and about 90,000 is due. In the facts and circumstances, the appellant is granted opportunity to pay the same by installment.
Yes, I'm grateful.
In the first installments, the appellant shall pay rupees 30,000 on or before 2/2/2026.
February 2.
February 2/2/2026, you pay 30,000. The next 30,000 shall be paid on or before
First week of March.
On or before 1st March 2026, and thereafter the
Without
balance
giving
amount-
exact first week of March.
I'm making it 1st March.
Exact date, my lord. 1 or 2 days they will be missing. So first week of March.
On or before 5th March 2026.
Yes,
And the balance amount on or before 3rd April 2026. Let this matter appear for hearing on. Oh, you want to file your affidavit in reply?
Yes.
Let's reply.
Affidavit in reply
Yes.
to your opposition.
2 weeks enough.
28/1/2026.
Let's.
My lord, interim order will continue.
Yes, interim order shall continue for a period of 6 weeks or till further orders, whichever is earlier.
I'm grateful, my lord.
Lord,
In the
we have
morning they
also,
came,
my
I
lord,
said that you deposit the amount.
my lord, we have also, my lord, another appeal, my lord, COT, my lord, that is not appearing with the list.
That should be heard analogous.
Give the slip, it will appear.
It will appear.
I'm extremely grateful, my lord.
My lord, I am appealing for the respondent number 1 to 7.
I appear for the
Last
appellant.
Yes,
occasion,
on
my
the
lord.
last occasion, you
Yes, sir.
received both of you
Yes.
received the report of the special officer. Do you want to take an exception?
Yes.
So serve a copy upon your learned friend.
They
Already
have.
Find an objection to that.
They have.
Yes, record an order. Learned advocates for the parties and the learned special officer are present. The respondents have filed an exception to the report of the learned special officer. Let copy be served upon the learned advocate for the appellant.
Already served.
Already served.
Okay, author.
Yesterday, sir.
Copy have you served upon the special officer?
No, he refused to take the copy.
Okay. Let a copy be served upon the special officer also. The appellant is permitted to file affidavits to the exception on or before 21/1/2026. Let this matter appear on 27/1/2026.
Your 27th.
27th.
In my report, my lord, inadvertently, my lord, respondent number 3 instead of opposite party number 3.
Okay, that you clarify at
Because
the
it
time
was
of
their
consideration.
application, so the cost title had to
Anyway,
be.
that you can clarify.
Yeah. I'm grateful, ma'am.
Yes.
Yes.
Friends, take the time for the appellant.
My lord, I appear for the respondent, your lordship.
Orderটা কোথায় গেল?
My lord, by an order dated 9th of June 2025, my lord, their lordships, the Honorable Justice Bhattacharya and my lord Justice Kumar, my lord, had granted stay of operation of the impugned judgments and decrees of both the courts below till disposal of the application.
So the appeal is ready for hearing.
Lordships, LC.
My lord, LCR has to be called for.
And Lordships absolute the interim order till the disposal.
You are for the appellant.
Yes, Lordships.
So trial court's records have not come.
Lordships.
Yes.
Lordships.
So your
Let
lordship
it be called for at the special messenger cost of the appellant.
Yes.
Yes, Lordships. The appellant is very poor person. They are.
No, otherwise it will be delayed.
They are trying to delay it.
Lordships,
My lord, two courts have, my lord, given judgments in my favor.
You want You want
Lordship,
to
this-
bring it at your message,
this is
special
Lordship
messenger
work
post?
of party.
Yes, your lordship. Yes,
Record
we'll
an
do it.
order.
আমরা নাই
Learned advocates for the parties are present.
পয়সা খরচা করে আমরা থেকে নিয়ে আসি
Let the trial court records be called for at the special messenger cost of the respondent. Let this matter appear on 29/1/2026.
It's a usual process, Lordship. The appellant Lordships, poor person and work of poverty. This is
I am
not
ready and willing to, my lord, bring the record by my price, at my cost.
You are not suffering anything. I'm just, after the trial court records come, I'm keeping it on 29/1/2026.
Yes.
Okay.
29th Lordships. Today is 14th.
It's upon me, my lord. I will bring it at the cost.
If the trial court records come, the
Yes.
matter, there will be a direction to file the paper book.
Absolutely, your lordship. Deeply obliged.
And the Lordship, the next interim order.
It is there. It is already there. It is already
Achha,
there.
the interim order is still disposal.
Yes, your lordship. Yes, it is there. It's there.
Please disposal of the application.
তাহলে আর absolute কি আছে? It's already there. কোথায় গেল?
It is also absolute by your Lordships.
ভাই এক্ষুনি তুই তোর হাতে দিলাম না মারবি আমাকে এই যে না 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 হ্যালো এই যে yes my lord below till the disposal of the application my lord it's there deeply obliged
But one matter has been passed over, both sides are here.
So can 2 is to be taken up for consideration.
Yes, please. They have, but this is our affidavit in reply, my lord. They have served it upon us, my lord. It is Jamane. না না ওই অ্যাপ্লিকেশন গুলো অ্যাপ্লিকেশন আর অপোজিশন আর রিপ্লাই ক্যান টু এটা অপোজিশন থাকে আর রিপ্লাই এটা অপোজিশন হ্যাঁ এটা করতে দিন এই হ্যাঁ 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 ওটাই অপোজিশন অপোজিশন এটা হ্যাঁ 1786
Yes, Mr. Banerjee, you are for the appellant.
Yes. A memo of appeal to Judge sir.
Anyway, let me consider this application. The appeal is already admitted. The
Appeal-
interim order is continuing.
But interim order, my lord, that was the pleasure of my lord justice. Judge sir, please. না 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 তারপরে
Let me see the order of admission.
Justice Bibhash Ranjan De to hear out the appeal. But that is why the interim order was extended from time to time,
Yes, yes.
giving dates for final hearing of the appeal without passing any interim orders or occupational charges upon the
Okay,
appellant.
let me see the order with regard to admission.
Admission, Lord. Kindly peruses. It is order dated 29th April 2024.
25, 29/8. No, this is with regard to the order of the single bench, the order of admission. Let me see that.
Admission is 29th April 2024. দেখো Lordship has got it.
Let me see.
প্রথম অর্ডারটা বের করে
April 2024.
ভোরবেলা
Yes, so it was for a limited period
Yes.
and parties were granted liberty to file affidavit in opposition and reply. Yes.
Now, my lord will kindly come to the order dated 10th January 2025. 10th January 2025 by Justice Bibhash Ranjan De. Lordship has got that order.
10/1/2025.
Lordship.
Yes.
Lordship will kindly see second paragraph. It is found from the record that the trial court record has already been received and except record of ejectment suit number ATO for which notice has also been issued by the department. It is also submitted on behalf of the appellant that informal paper book has already been prepared and submitted in compliance with the order dated 29/2024. Considering the facts and circumstances, the appeal is found almost ready for hearing. The application for stay shall be heard along with the appeal. Department is directed to transmit the trial court record along with informal paper book before this court on the returnable date. Let the matter appear under the heading hearing on 7th February 2025. It was the pleasure of this honorable court to hold that stay will be heard along with the appeal.
My lord kindly takes up the order.
Yes.
Kindly takes up the order dated 29th August 2025. Passed by Justice Bibhash Ranjan.
29/8.
2025.
So this was the order passed. 29/8. Yes.
My lord kindly see the stay. The counsel for the appellant prayed for extension of the interim order of stay. The counsel for the appearing on behalf of the respondent opposes the prayer by submitting inter alia that the date may be fixed for hearing of the stay application. In terms of after hearing both sides, this honorable court was pleased to fix hearing of the stay application.
What do you want? The appeal to be heard out or this application?
This application first may be disposed of.
Okay, very well. Then you submit on this application.
Yes, my lord. Kindly takes up my opposition, my lord.
But then I have to make submissions on my application, my lord.
Very well, submit. I'm taking it up.
My lord, they know it very well that apart from imposing occupational charges, they have nothing in this suit.
Whatever it is, you see, this application is pending for a long period.
But it has been the observation of the court, my lord, that the stay application.
No. You see, either you see, proceed with this application or let me fix a date for appeal. Your learned friend.
Yes, my lord, kindly fixes up any date, my lord. It will hardly take 5 minutes.
So there will be no stay. So
they will.
So I have to clarify that there will be no further stay.
But that will be a predicament for my client.
See, once you
very well, my lord, may kindly take up the stay application once. But this is imposing something against the order once passed. My lord, they are trying to impose that.
Very well. Whatever the division bench has passed, okay, that was for a limited period.
Yes.
Thereafter, the matter came up before the learned single judge.
Yes.
And the learned single judge also fixed it after a particular period for the hearing of the stay application. So let it be heard out.
But there was also an observation that it will be heard along with the appeal.
Very well. Now,
Order was there.
But that order has not been,
as the appeal could not be heard out, the
Yes,
court has
but
to pass.
appeal is ready, paper books are here,
But you see, there are
trial court records are
appeals,
here.
many appeals which are pending. Okay. In the meantime, some limited protection has to be given. Okay. Otherwise, the entire appeal will become infructuous. So for that protection, it is necessary to consider this application.
Lordship will kindly take up the stay application, my lord.
Yes.
Appeal court and decree corporation. Appeal court. Decree. Lordship, may I place it, my lord?
Yes. Yes, please.
My lord, suit on the ground of default and subletting. My lord, what subletting? The husband of one of the respondent has been named to be a subtenant. My lord, this was decreed by the trial court. The first appellate court took up the matter and observed that 2G has crept in. Without giving any opportunity of hearing under 2G, without there being any ground, the decree of the small causes court, which does not have the jurisdiction to decide 2G was considered. Malad, the appeal was, in the appeal, the trial court decree was affirmed.
So it was a suit under Section 6.
Section 6.
Okay.
Wherein a decree was granted on the ground of 2G by the appeal court. Malad, we were paying during the appeal court proceedings occupational charges of rupees 2200. Malad, that is my last annexure at page number 89. 88, 89.
Yes, 22,200.
Yes.
Yes.
Now, Lordship would be kind enough to find, my lord, what they have written in their opposition. My lord, they say they have annexed, my lord, a report by one chartered engineer.
No, this is your application. Okay, opposition.
Opposition.
Which paragraph?
My lord, they have given the annexure, my lord. It is at page number 9.
Yes.
But it has nothing to do with occupational charges. Lordship will kindly find the first two lines. Fixation of fair rent.
Okay, para 9.
No, page 9, my lord.
Page 9.
Page 9.
Page 9.
My lord, this has nothing to do with, fixation of fair rent and whatever. But the engineer commissioner or the chartered engineer proceeded on the premise that it is fixation of fair rent for 2 rooms, and he says the measurement is 240 square feet. Now, Lordship would kindly turn over to the second page, page number 10. Malad, in the middle, the location is about 120 square feet inside from 12 feet 6 inches Raja Rajvallabh Street. The connected path, 120 square feet in length, is of varying width of 3 feet to 5 feet, which is almost impossible to move even for a rickshaw. Rickshaw also cannot enter. Now, my lord, kindly takes the photographs given in page number 11. It is their report.
Yes.
Page number 11, it shows the condition of the building, my lord.
Which one? Okay, page 10, page 11.
Page 11, in black and white, but still it is evident that the property is absolutely dilapidated.
For what purpose? Residential or non-residential?
Residential.
What is the area?
But it is, but we have given 120 square feet. I will show that, my lord, for a moment.
Okay.
Kindly come to the commissioner's report, how he makes an assumption of the area and the occupational charge or the fixation of fair rent.
This is what architect's report.
Architect's report. Malad will kindly consider page number, running page number 24. I'm sorry, 14.
Yes.
Malad, he deduces in paragraph number 14 of the report, undivided share of the land area pertaining to tenants part. But this is absurd. 189.90 square feet. Paragraph 15. Value of undivided share of appertinent land pertaining to tenants part. Not absolutely unheard of. 9,05,355. Now he gives a cost of construction. He gives a depreciation. Refers to the report of the registry office.
That is page.
Malad, registry office report is at page number 18. 18.
Yes.
And says the market rent, I mean the fair rent should be at page number 17, 13,180. পুরো opposition কত বলেছে? Opposition 80 opposition 8 এখানে কত বলে দিল? But 54 rupees per square feet.
Yes.
Now, Lordship, what has come from the chartered engineer, Lordship would kindly once turn to page number 8 of my affidavit in reply. What is the property where the tenant stays?
Page 8.
Page 8?
Yes, affidavit in reply to the.
আজকে রিপ্লাইটা জজ আজকে যে রিপ্লাইটা দিলাম
Yes.
Malad kindly turns to page number 8.
Yes.
Now, this is where I am staying, Malad. I'm a widow lady. I have basically no income. My son has not joined me in this second appeal also. Is a pro forma in before your lordship, my lord. Plastic, my lord, on the roof. Through that the fan is hanging, and these are the conditions of the room. But 2,200 square feet was before the trial court. I mean the first appellate court.
Area is how much?
120 square feet.
40 square feet.
What we have categorically stated. But kindly see the room.
Room, how many rooms?
Two rooms, nothing else.
At Hathibagan.
How can it be Hathibagan, my lord? But it is Rajbollo Pada. Rajbollo Pada. No, Hathibagan is far away from
Not
that.
Calcutta.
Not far away.
Yes.
Not Calcutta, not Calcutta.
No, my lord. Rajbollo Pada.
Kolopara is not Calcutta.
Yes, but not Hathibagan. Hathibagan is far
5
away.
minutes walk from Hathibagan. It's near, closer to the crossing of Bagbajar.
Okay, this is the picture you have annexed.
Yes. My lord, kindly see the rooms.
It's a better picture. I think in their opposition, it's
more
deteriorated. It's
more
a better
worse.
picture which you have annexed.
Yes, this is the inside condition of the room. And they have given the outside picture. And they say 54 rupees per square feet. But 2,200 square feet we were still paying. But kindly does something so that my client can at least contest this. But her condition is such, she cannot withstand this.
How long she is residing there?
Well, maybe 40, 50 years since her marriage. Since her marriage.
So anyway, you have dealt this. Yes, what do you say?
Lordship kindly comes to page 9. That is my plane. And 9 of the stay application. Now Lordship kindly comes to page 13. This is my schedule.
Yes.
All that 2 rooms situated on the ground floor with common bath and privy situated on the ground floor premises number 7/6.
Now page 9.
Page 13 of my stay application. Page 9, my lord, the plane starts. The relevant schedule is at page 13.
Yes.
All that 2 rooms situated on the ground floor with common bath and privy situated on the ground floor premises number 7/6, Raja Rajbollo Street, Police Station, Shampukur, Kolkata 3. So this is in the heart of the city. It's a very good location. It's well connected by bus, metro and everything with all the amenities and all the facilities which the Honorable Supreme Court has taken into consideration while fixing, my lord, the occupational charge. So these being the market position, my lord, they are now liable to pay occupational charge as per the market value, as per the dictum of the Honorable Supreme Court. They are enjoying stay on the one hand, and on the other hand, they are paying nothing. Lordship, kindly also appreciate the other facts, being that the ejectment suit is of the year 2008. The suit was decreed in 2017. They preferred an appeal before the first appellate court. The first appellate court passed an initial order of occupational charges. That was in the month of February 2018, 7 years back.
So in 2018, how much was the occupational charge?
In 2018 February, it was directed to be paid 2,200.
Which paragraph you have stated that?
Yes. If your lordship kindly comes to page.
Page?
This has been stated in their stay, my lord.
No. Yes.
Now, at that point of time, the report that I have annexed.
The building has not improved. There is no renovation of the building.
But the locality has improved. The locality is fetching more now.
You see, better an old person has to reside comfortably in a building. In a dilapidated building, the valuation of the building has not increased.
Lordship, the
criteria, an old building.
The criteria is if I let it today, how much I will be getting. That is the.
Now the other question is, yes, which paragraph? In page?
Para 14, stay application.
Para?
Lordship kindly comes to page 85 of the stay application. They have annexed one such receipt. 2, 3 receipts.
That means this occupational charges was taken up into consideration by the first appellate court.
By the first appellate.
And 2,200 was imposed. Yes, which page? That is 60?
Page, Lordship kindly comes to page 85. One of the receipt has been given.
85.
Page 85 of the stay application.
Okay.
So there was this para 14.
Para 14, stay application.
And in para 14, my learned friend has stated.
Just a minute.
at page 6 of the stay application.
Page 85, that is, okay.
And coupled with
This
that,
is in terms of the order of the first appellate court?
Now, Lordship, kindly
That
see,
is in, when was the order passed?
the order was
2018.
passed in February 2018, 7 years back, more than 7 years back. In the meantime, my lord, situations have changed. The locational value has enhanced. The dicta of the Honorable Supreme Court is
Oh,
that
he's continued to pay this amount?
no, paid for some time, thereafter they have not paid.
When did you pay last?
But we have paid till the disposal of the appeal. Thereafter, we could not have paid.
Disposal of the first appeal.
Yes. Malad, that was till August 2022.
At that point of time, my lord, the value.
August 2022.
Lordship.
Now we are in 26.
But if my client is directed to pay it together, she will have to leave.
No, at least you see the first appellate court matter. But what will happen? These areas, for example, either I hold, either enhance or I accept the appellate court. But what will happen for this period?
But area have to be paid.
That is what I am telling you.
Malad, but her condition is not such.
Anyway, some installment has to be granted.
Malad, a lady residing in
some installment has to be granted.
Compelled to reside in such a property, she is waiting her day to come. This is the condition.
So what is the age of this person?
Apnar boyas kato? He's 64 years.
Anyway, you see one thing. Question is, you see,
but I
the
understand.
court either have to accept the order passed by the appellate court, that is the first appellate court, or enhance, or pass further orders, whatever it is. But you see, whatever order I pass, either accept it or enhance it or direct it further inquiry.
I understand.
You see that you have to pay from the date of the decree of the appellate court, first appellate decree, that you cannot avoid.
But I understand, my lord. But
either you have to be granted some installment.
But I have expressed the condition of my client.
2022, this appeal was admitted.
Yes.
No,
but the appeal was admitted on
4th January 2023.
The appeal was filed in 23, kept pending for some time.
Yes.
Thereafter, they got it admitted.
Yes.
Just in order to not to pay the occupation charge.
But why didn't you file application for occupation charges, all these things, keeping this huge area pending?
And unless and until
no, appeal after admission of the appeal, you could have filed an application.
We have made that prayer at the time of hearing of the said application.
Because now you see this is an area.
We have contended that in our affidavit also.
That means 3 years occupation charge is pending.
Yes. And Lordship, may I just humbly submit to your Lordship only the direction of the Honorable Supreme Court in Atmaram's cases, which is the guiding line.
No, question is, you see, if you are aggrieved that the stay is obtained without payment of occupation charge, why didn't you file an application for occupation charges for this past 2.5 years?
Generally, along with the stay application, it is being directed to pay. Now, Lordship, kindly seize once, Lordship, paragraph 18 of the Atmaram's judgment. Kindly seize it once.
No, whatever it is, the occupational charges are to be paid.
Yes, definitely,
but
they have
this
to pay.
Huge burden, you see, by keeping this matter pending for a long
they
time.
knew about it, my lord. They knew about it because they have paid occupational charge at the appellate court while enjoying stay. Since they are enjoying the stay over here, they are under concomitant obligation to make the occupational charge, pay the occupational charge.
Yeah, but that you could have moved this earlier.
Even my lord, the obligation is upon them. They could have said before the honorable court that I am liable to pay occupational charge. They have not done so. So they have not moved in a bona fide manner.
Anyway, you see, you are also a landlord. You have also some obligation because they have obtained an order of stay. You could have fought it out.
Lordship, kindly appreciate the matter is going on. Lordship, kindly appreciate the matter is going on for a pretty long period of time before us.
So after 2022, the COVID period is over. Okay.
Yes.
So you could have filed this necessary application.
They short time to file affidavit in reply to our affidavit in opposition. For that, at least 6 to 7 months has elapsed.
Now the question is, if he agrees to pay the all areas occupation charges, okay, within 1 month or something like this, or partly some now or partly after 1 month, are you ready? The areas as per the first appellate court.
My lord, before that, I will only place one paragraph of the Atmaram's judgment. Only once. Lordship kindly takes the pen to look into it.
Page?
Lordship kindly comes to the judgment, 2005-1 SCC, page 705 at para 18. My lord is at paragraph
Para-
18,
para
page is 717.
Yes.
Lordship kindly takes the trouble to come to para 18. That apart, it is to be noted that the appellate court, while exercising jurisdiction under Order 41, Rule 5 of the Code, did have power to put the appellant tenant on terms. The tenant, having suffered an order for eviction, must comply and vacate the premises. His right of appeal is statutory, but his prayer for grant of stay is dealt with in exercise of equitable discretionary jurisdiction of the appellate court. Lordship, I pause here for a moment and put emphasis on the term equitable discretionary jurisdiction of the appellate court. While ordering stay, the appellate court has to be alive to the fact that it is depriving the successful landlord of the fruits of the decree and is postponing the execution of the order for eviction. There is every justification for the appellate court to put the appellant tenant on terms and direct the appellant to compensate the landlord by payment of a reasonable amount, which is not necessarily the same as contractual rate of rent. In Marshall Sons and Company Limited vs. Shahi Oratons, this court has held that once a decree for possession has been passed and execution is delayed, depriving the judgment creditor of the fruits of decree, it is necessary for the court to pass appropriate orders so that reasonable mean profit, which may be equivalent to the market rent, so kindly sees market rent. So the market rent in 2018 is different than the market rent of today after 7 years, paid by the person who is holding over the property. And for the purpose of stay, before your lordship, this is the relevant appellate court. So your lordship has
how much it comes for the past 3 years? If, for example, so
2200 করে
and lordship also appreciate the amount if they had paid and the amount was put in a government security. And so far, my lord is concerned, my lord is the appellate court where my lord has to consider these conditions. There is the market value and all these things because the stay is being granted afresh.
This, please, it was, I think the order was passed in your presence, probably after hearing you. Yes.
We were we were not there.
Admission order.
Yes, my lord, they were there.
Because you see,
No,
when the interim order was passed, you could have
No,
made
no.
that prayer
Well, they were
for
present.
occupation charges.
They
So
were
that
present.
will not act as a res judicator, lordship. I submit
Now,
with
another
greatest
thing is
of
that
respect.
how much it comes? 2,200
Yes.
into 3 years
Yes.
or 3.5 years, something like that.
No,
3 years for the purpose of not paying it, and for the purpose of making payment right now, they have to pay as per the market value.
41 months হবে
Now you see,
accord.
Because each and every incident of praying for a stay is different, and on each and every occasion, different material will come into play.
Malad, it
for
comes,
consideration.
it is 41 months.
That is why Lordship kindly sees Honorable Supreme Court has clearly said that equivalent to the market rent, the market rent of 2026 is much higher than the market rent of 2018.
Malad, it comes to 41 months, 90,200.
now the question is, you see, the no courts can permit a person to occupy without payment of the occupation
Malad, I
charges.
leave it to your lordship.
For example, you see, I decide today that so and so should be occupational charges or so, or I send it for further inquiry, but I cannot exempt you for paying these
Malad,
things
I do not.
for all this.
Malad, I
period.
cannot say
So,
that.
will you be able to pay?
Malad, very difficult, my lord. She will give it a try, my lord, if
No,
possible.
you see the 41,000, how much? 1 lakh.
No,
90,000, 80,000.
And as per our calculation, more than
88,000 something. এটা ভুল হচ্ছে কিনা দেখে দাও।
90,000 something আসছে আমাদের কাছে।
Because you see,
অগস্টটা উনি দিয়েছেন। হ্যাঁ, সেপ্টেম্বর থেকে হবে।
because see that occupation charges is still prevailing.
8,000 পুরো। It is 88,000.
See, I cannot exempt you from making this
Malad,
payment.
I never
If
say
I
so.
consider your case, this case, okay, that exemptions I cannot give you.
Malad, I never say so, my lord.
The case was pending for a long period.
But it had been the pleasure of the other judge, my lord, to take up the appeal.
No, but you
We
see,
were expecting that to happen, my lord. We further
I
reiterate.
also appreciate the conduct for 6 to 7 months. They have taken time to file the affidavit in reply.
No,
This is why they have dragged it.
Very well, leave these 6-7 months, there are other months, these 2 years. What these 2 years?
88,000 পুরো হচ্ছে 40 months সেটা লেখ চর্চাটা দিতে হবে তো but 40 months in total it comes to 88,000
Because there is no scope to adjudicate that aspect. Okay, what at best I can do is adjudicate this, the present one.
and we are left to your lordship, my lord. It's a very difficult condition for the lady. This is what I have instructions.
But Honorable Supreme Court has clearly said, my lord, with deepest respect and humility, lordship, I say that it has to be a equitable discretionary jurisdiction of your lordship.
But
when my
whatever
lord
we
has to decide
kindly
this.
takes up the appeal as early as possible. Kindly spare us half an hour time, my lord.
He
Both
cannot,
of
she
us.
cannot be a privileged
But I cannot, you see, whatever.
But
that
I
is-
can make a
to-
prayer before your
see,
lordship. my lord.
See, the courts are not empowered to grant exemption to a party
I
to
never asked
continue
for
without
exemption.
occupation charges.
But I never asked for that, my lord. But it's a very difficult situation.
Anyway, so anything else to submit?
No.
With regard to the facts?
So for the facts are concerned, lordship, I have filed the report which my lord has seen. That brings out a very true picture of the locality, the condition of the premises, the area the lady is at present possessing, and the amount of market value, if I let it out today, it will fetch. Which are the only consideration which will be taken up for, which may be taken up for consideration at this time when a fresh order for stay has been passed by this honorable court. Because we are now in 2026. And the last order for stay was passed in 2018, almost 7 years back. Considerations were different, material things were different, parameters are different, and all these things have changed. And there is nothing on record which rebuts such report. And Honorable Supreme Court has very unequivocally has spoken up and said that it should be equivalent to the market rent. So if it is equivalent to the market rent, in that case, it will be the rent of 2026.
Okay, I'm fixing it. Yes, record an order. Learned advocates for the parties are present. Hard learned advocates on the application for stay being Can 2. Can 2 of 2023. Hearing is concluded. Let this matter appear for orders on 22/1/2026.
Or only one thing, around 22nd, I have a personal difficulty. It may be on any other day.
I'll pass the orders. I think no further hearing is required. Or else, if you want, I can keep it on this thing.
On any-
28. Because you see, whatever you have, if you want to file any written notes, because whatever facts are there, it's there. But no further arguments. I have to pass the orders. Okay, 28/1/2026.
I'm grateful to your lordship.
Malad, would this calculation be required by your lordship, Malad?
Anyway,
Then we give it in a fresh
give it in a long sheet of paper.
ভালো করে পরিষ্কার করে লিখে করে দে But we are deeply obliged. But lordship would kindly also, after passing orders, find a date for the appeal hearing, Malad.
Yes, yes, yes.
We have filed our reply today, Malad.
Yes, yes, yes.
Grateful to your lordship.
The affidavit in reply and opposition file be kept with the record.
Opposition we have filed.
Or the affidavit in reply file be kept with the record.
Grateful to your lordship.
Great.
Yes.
Appeal ঢুকলে
দাদা এটা আলাদা করে পেপারে লিখে আপনাকে দিচ্ছি ফাইলে ঢুকিয়ে দেবেন
Number 27.
Lordship, I'm for the petitioner. The matter is mistakenly not admitted.
So let me go before. Yes, record an order. No, is section 5 application pending?
Yes.
Oh, then that has to be disposed. So if section 5 application is,
serving it. Yes.
if section 5 application is pending, it has to be considered upon service of notice to the opposite parties.
I'm serving it.
Yes, learned advocates for the parties are present. Let the application for condonation of delay be served upon the respondent. Let this matter appear on 19/1/2026.
My lord, item number 28, I'm appearing for the claimants, my lord. I'm led by Mr. Uday Shankar Chattopadhyay.
Lordship Shantanu Mitra is appearing for respondent number 5.
Okay, not today then.
My lord, only one thing, my lord. I don't have any papers related this appeal.
No, paper books are filed in this matter.
No, my lord.
So the how it has come for hearing? Paper books file hoyeche etate. Paper book file hoyni.
My lord, kindly, I'm praying for an order, my lord, for certified copy from FMA section, my lord, for the certified copies of the.
Okay. Trial court records have come. Yes, record and order. Learned advocates for the parties are present. As the trial court records have come, let the paper books be filed on or before 9/1/2026 by the appellant. Let the trial court's records be sent to the department to enable the learned advocates to obtain copies of the documents to file the paper books.
Grateful, madam.
Yes, not today.
My lord, I'm praying for not this week, my lord. Can't favor it.
30, you are for?
Asik Mandal. 30 wrong. No matter I mentioned.
No, you are for appellant.
No, he is not in this matter. All parties are here.
30/31?
Yes.
30, who is for the appellant?
I am for the respondents led by claimant led by Mr. Bonik.
Your Lordship, may remember this is a matter, the direction to the railway authority to file the Form 16 by way of affidavit. And I have got it and may I file this? I have served the copy. Right, 25th September 2025, this Honorable Court directed my lord, the railway authority, my lord, to submit the Form 16. My lord. That has been annexed R1, my lord. Copy has.
As per Form 16, how much was the income tax deducted? 3316.
Page 4, madam.
Page 4, yes.
Madam, that is 3,316. Total taxable income.
How much award? So, while passing that award, this income tax was not taken into consideration.
No, my lord. One thing, my lord. Kindly allow me to, my lord, give the nutshell of this case. My lord, the disease was a railway employee. My lord, aged about, my lord, 42 years old. Now, my lord, his earning was about 52,000. Now, my lord, he died in a motor accident. Now, my lord, award was passed to the tune of rupees, my lord, 68,000.
No, you are the appellant.
I'm for the, my lord, respondent. I'm giving the nutshell of the case, my lord. Well, the award was passed only to the tune of rupees 68,088. 68 lakh 88,000.
68 lakh. Yes.
88. Now, my lord, on the basis of the income assessed by the tribunal as 48,000 income for month. Now, my lord, the insurance company, my lord, challenging that award, prefer an appeal on the ground that the tribunal did not deduct, my lord, the income tax, my lord, from the income, and the income whichever is taken tribunal, that is just 48,000. Now, my lord, we, my lord, file a cross appeal. My lord, in the cross appeal, my lord, we have taken the two grounds that the, my lord, regarding the multiplier, regarding the, my lord, the, I have no disputes, my lord. My lord, I have taken the three grounds. The, my lord, the learned tribunal are in law, in fact, not in assessing the income as 48,000 per month. It should be, my lord, 52,000 less tax deducting. That should be taken by the tribunal. The learned tribunal has taken the 48,000. That is the
What is the, let me see, which page is the pay slip?
pay slip, page 30.
Page 30 is the.
Exhibit 7 series, page 30 of paper book.
Yes, yes.
That is the, my lord, he
So
died.
February, died in which year?
My lord, 2017, the month of March. My lord, date of accident is 22nd March 2017. Now, my lord,
So this is for February
this is now
2017.
December, January, and February.
Yes.
My lord, it appears, lordship kindly see the page 30, my lord, top basic or pay is 52,000.
That is December 2016. Okay.
Yes. Now, my lord, the second part is, my lord, that is January 2017, basic pay 52,000.
Yes.
Now, my lord, March also it appears that, my lord, in the left hand side,
No, no. This
basic
is
pay
also February.
52.
Probably the bottom one. That is also probably February.
February. And March he died.
Yes, yes, yes. That
It's
is
page
February.
30, 52,000.
So it is 52,000.
And, my lord, it appears from the, my lord, the pay slip that the professional tax, my lord, your lordship kindly see
200.
right hand side, 200.
Yes.
And thereafter, my lord, 150. And thereafter, 200. Now, my lord, the disputes, my lord,
These payslips were tendered by the claimants.
my lord, these payslips were, my lord, tendered by the, my lord, my clients, and it was marked as Exhibit 7 series. Now, my lord, learned tribunal, my lord, holds that if the income is 52,000, so, my lord, income after deducting, my lord, the 2,50,000, my 10% deducted.
So the learned
Learned
tribunal
tribunal-
proceeded on what income? 48,000 or
48,000. Your lordship
Okay.
kindly turn
So
to
from now, 48,000 without no question of professional tax or income tax.
Income-
Straight away 48,000.
48,000.
Okay.
That was this, that Banat I am challenging in my court. The court was, Banat delay was condoned and court would be heard. And then matter was hard,
But this income tax was not taken into consideration. 3316.
Yes. Now, my lord, second ground which was taken in my cross appeal is that the Alden Tribunal has not granted the general damage as 86,000. My lord, Alden Tribunal has granted only 25,000 or 35,000. 25,000 loss of consideration and 10,000 is loss of estate and something. That as per the Pranay Shetty, my lord, it should be, my lord, 84,000. That is 70,000 plus 2 years, every 3 years, 10% increase, 84,000. That was taken. And also, my lord, I have taken the loss of parental consortium. Now, my lord, the matter was, well, the insurance company desired not to press the appeal, and the, my lord, the award, my lord, be confirmed. Now, my lord, we are, my lord, questioning before Her Lordship, the Honorable Justice Anuna Bandyopadhyay, since my court, my lord, is pending, court should be adjudicated. Now, my lord, your lord, Her Lordship, my lord, desire the, my lord, directing the, my lord, the Registrar General to send the matter before the, my lord, the tribunal. And before the tribunal, the Railway Authority has come, and also Income Tax Department has come. They adduce the evidence. Now, my lord, Her Lordship were not satisfied. The Income Tax, my lord, the authority or railway, my lord, the witness. My lord, thereafter, Her Lordship desire directing the, my lord, the railway to file the Form 16.
So that the railways have done
Railway
by
has done.
supplementary
Now, my lord, matter is, my lord, finished. Now, my lord, if, my lord, appears the income, my lord, the income tax, my lord, form is, my lord, the affidavit, the 3,316. So, my lord, divided by 12 or divided by 12, that is, my lord, the taxable income per month. 52,000 minus, my lord, 200, 220, 200, 2000, 2060 or something. No, 200, 2600 টাকা. And my lord, the evidence, my lord has produced, the ration negligence point has been proved, everything proved. Now only
The ground of challenge by the insurance company was the quantum.
Quantum.
Yes.
My lord, on the basis of the, my lord, information.
Your challenge was also with regard to the quantum.
Yes, also in court. My lord, I have the, my lord, the 3 points, my lord, in my court, that the arbitrary assessment of the regarding the income. Second, the general damage, 84,000 was not granted, and my thirdly, parental consortium. Now, my lord,
yes, let the appeal says.
one thing, my lord. Kindly see, my lord.
So what is this calculation? Your calculation?
Calculations is, my lord, I am giving my learned friend.
So very well, I shall consider that, your calculation.
My lord,
Now- Yes, yes, yes.
And my lord, this is, my lord, the income from per month, and this is, my lord, income per annum. My lord, this is another calculation, not allowed. No, no, কিছুই না। On দিচ্ছি তো রে বাবা। On the basis of the income per annum.
Oh, this is income per annum.
Income per annum.
And this is income per month.
Income per month. Same.
So various way to analyze.
My lord, your lordship finish the matter. My lord, your lordship, by the kindly see the last, my lord, I have.
Yes, let
in the
Mr. Singh
status,
submit
at
and
least
come with his
28 days, my lord, the matter was.
Let Mr. Singh come with his own calculation.
Yes.
And let him submit.
Yes.
You want to submit or come with your calculation?
I need to go through this, Milord. What is this? Because Milord, difficult
time.
Milord, difficulty is, Milord, earlier at least 3-4 of these sheets have been given. My lord will kindly find them, those in this order sheet, Milord, my lord's file. So this is sheet number 5. This is
Just
sheet...
like you see, there may be several judgments in MSCC cases. In this way, several facts will change.
This is difficult. Your Lordship will kindly see my Lord's file, my Lord.
My
These seats are there or not?
Right and now, my lord, if it
এটা
is
আমার আগে দিলি না কেন?
Anyway,
ওই
now question is, your ground of challenge was with regard to that income tax matter. That was not taken into consideration, and maybe adverse with regard to the quantum. So whatever you want to submit, you may submit today, or you come with your own calculation.
Lord, let me see if this is correct, my Lord. I will not be arguing. But if I find
Bring your own calculation.
But if I find any fault, my Lord, I'll point it out to your Lordship.
I come with your own calculation also.
My Lord, tomorrow I'll
What
come
should
back to your
be?
Lordship.
let it appear as forward as to
Yes.
Learned advocates for the parties are present. Heard learned advocates. Let this matter appear for orders on. So tomorrow or day after tomorrow?
tomorrow. Day after tomorrow, দরকার নেই মানে ফ্রাইডে আফটার টু ভালো ম্যাটার
আমরা শুক্রবার সকালে
শুক্রবার কোর্টই হবে
North
নর্থ বেঙ্গল সার্কিট বেঞ্চ ইজ ওপেনিং
No, I will be available. So
my Lord would be here.
But you will not make yourself available.
মানে
You are more
tomorrow
My Lord, your Lordship would be here on Friday.
Yes, I'll be available in the
On
morning.
Friday. We'll do
Most
it
of the judges will be available in the morning. Yes. In the second half, many will not be
My
available.
Lord, on Friday morning we'll do it.
মালার বার possibly bar will be
Then
taking
Monday. If there
Non
is he's
March.
having so much of problem.
tomorrow Mala he has a Mala time 1 day time tomorrow your lordship কালকে করে দে না
দেখতো এই যে কাগজটা আমাকে আগে দিয়ে দিলে তো এত কথা হতো
না আজকে তো সারাদিন আছে তো দেখে কালকে করে
Anyway, if you are unable to come on Friday, I'll take it up on Monday.
no Mala keep it on tomorrow Mala my request is keep it
One day you will, you see, it's pending from 2022, and one day you will not suffer any
Mala your
irreparable
lordship
loss.
kindly see 28 days Mala matter has been CAB thereafter the Mala the story has been
You
changed
see, you are waiting for this last 3 years. You can wait for 2 more days.
My Lord, he has got fees for 20 appearances.
No. Malas is a advocate matter, Malas. Advocate relation matters.
No, definitely.
It is my
So,
pleasure, Malas.
Friday, Friday has a specially fixed matter in the top. On 16/1/2026 as a specially fixed matter at 10:30 a.m. top.
Grateful to your Lordship. Right. কি এত অসুবিধা
আমি শুক্রবার কিছু না
আমি থাকবো জজ স্যার থাকবে তুমি থাকবে
My lord, praying for not this week, my lord.
Okay, not this week. Yes, not today.
Evening. My Lord, 35 is insurance appeal.
Yes.
My Lord, pursuant to your Lordship's earlier direction, my Lord, the entire awarded amount is secured before your Lordship's court. My Lord, in this case under section 163 capital A, my Lord, an award of 4,70,000 was passed, which is secured.
Maximum amount is 5 lakh.
My Lord, yes, maximum amount is 5 lakhs. My Lord, there are two conflicting judgments, my Lord. I must also indicate, my Lord, it was perhaps indicated to your Lordships earlier also. But, my Lord, I would not be disputing this 5 lakhs. My Lord, let me be candid. If we, in my appeal, if she gets, my Lord, apna ki cross ache, didi? Ache. My Lord, in my appeal, if she gets, my Lord, rupees 5 lakh, the award is of 4,70,000. If it can be enhanced to 5 lakhs, my Lord, I would not be
There is a
disputing
cross
that.
objection, yes, court is there.
My Lord, I'll just
The
give
matter is ready for hearing.
matter.
63 Lordship, my landed bill is submitting the
My Lord, cross is perhaps not in the list. That is why it confused me.
Yes, record and order. Learned advocates for the parties are present.
They have already
As
received
the
cross
as
objection,
as
Lordship.
the cross objection is not appearing in the list, let this matter appear on
My Lord, either tomorrow, day after, my Lord, whenever, I'll
On
do it.
15/1/2026
Kalke.
in the same position.
Grateful to your Lordship. My Lord, I'll finish it off.
তো তোমরা এনেছো দাওনি কেন লিস্টে কবে এনেছো
Acha, let COT, give the number, let COT 155 of 2025 be listed along with this appeal.
Obliged, my lord.
Yes, not today.
37.
37, yes.
My lord, I am for the appellant. In this case, I have already given the paper book to the other side. I am filing the paper book to Your Honor.
So the matter is ready for hearing.
The matter is ready for hearing. It's a very small matter, Your Honor. In this case, what happened? It was allowed. In this case, instead of statutory compensation of 8 lakh, that is fixed in railway and toward case, it has been awarded 5 lakh. So this is the case, Your Honor. Instead of 8 lakh, it has been awarded 5 lakh. There is a gross mistake in this case, Your Honor. Paper book. Very small matter, my lord. No, I am saying, let me argue first. No, let me argue. I have not completed. This is a Railway Act. Page number 292, Railway Act. That is Railway Accident and Untoward Incident Compensation. There's a schedule. So for debt, schedule is 8 lakh, Your Honor. So this is a schedule of 8 lakh. Page 292, highlighted that, Your Honor. So it is a statutory compensation for debt in railway untoward case is 8 lakh. So in this case, what happened? Due to typographical error in my claim application, I have stated I am paying for 5 lakh. So for that, I filed a review in railway in RCT, and that review was dismissed. So I played for review that it was a typographical mistake. So due to mistake, instead of 8 lakh, I have paid for 5 lakh.
Okay, so let the matter be heard out.
Well, today I was ready for hearing, my lord.
Submit. Yes, are you ready?
Yes.
Paper books to dekhi. Yes.
I have not completed.
Anyway, let him submit.
Yes, Your Honor, in this only point is that, Your Honor, in this case,
Page 123, paragraph 8.
due to my typographical mistake, Your Honor, I have paid for 5 lakh in this case, but statutory compensation in that case is 8 lakh. This was my mistake, and I have also filed a review in this case, my lord. That is
So whatever you paid, that was allowed.
That was
and your review application was dismissed.
Review application was dismissed. In review application, I have stated that it was a typographical mistake. By mistake, I have paid for 5 lakh. It was not the mistake of the claimant. It was the mistake of the advocate. Then also that review was dismissed, my lord. Kindly, page number 113 is the review application, my lord.
Okay, just a minute.
Page number 113. I don't know, most surprisingly, in the judgment copy I am showing you, Honor, one thing.
Page 113.
Is the review application, and
Yes.
first come to judgment page number 123. In page number 123 of the judgment, they are themselves saying in the judgment, as per provision of part 1, rule 3 of railway accident and untoward incident rules 1990, for the death of page 123.
Yes.
8.1, my lord. As per provision of Part 1 of Rule 3 of Railway Accident and Untoward Incident Compensation Rule 1990, for the death of the victim, the compensation amount will be 8 lakh. So they are themselves saying there is a rule of 8 lakh. But due to my mistake, I have paid for 5 lakh. They are awarding 5 lakh, my lord. And for this mistake, I have filed a review petition that is in page number 113, my lord. And that review petition was also dismissed, my lord. And I have prayed in my review petition that it was the mistake of the advocate, not the applicant, Your Honor. This is a typographical mistake, and due to this typographical mistake, why will the applicant suffer? Then also, Your Honor, my lord, this review petition was dismissed, and 5 lakh has been awarded in this case, Your Honor. And Your Honor, in this case, there is one more thing that is regarding this 5 lakh to 8 lakh. There is one thing. Second thing is, Your Honor, in this case, interest was awarded from date of filing. So regarding that,
no, interest was awarded from the date of filing. So
no, according to Supreme Court judgment, no, there is not different. I have prayed for this, Your Honor. For this thing also, according to Supreme Court judgment, Your Honor, kindly come to point number 8. Point number 18 of the last page, Your Honor.
Point number, that is pay. Oh,
this Supreme Court judgment, Reena Devi, last page, point number 18, my lord. Rate of interest.
Yes.
We are of the view that in absence of any specific statutory provision, interest can be awarded from the date of accident itself when the liability of the railway arises up to the date of payment without any difference in the stages. Legal position in this regard is at par with the cases of accident claims under the Motor Vehicles Act 1988. Conflicting views stands resolved in this manner. The appeal will stand disposed of accordingly. So according to Supreme Court judgment of Reena Devi, interest should be awarded from date of accident in railway cases. Regarding that, I am filing the latest judgment of Jharkhand High Court also. This is a case of 19th Feb 2025. Kindly come to the last page.
Prior to filing this claim case, was any representation made before the authority for the claim?
Yes, my lord.
That was there.
That was there. That I am granting compensation from date of accident. That was in my claim application.
See, prior to claims moving the claim tribunal, did you move the authority for claim? Any representation was made before the authority for?
Yes, in my claim application, I have stated I am praying for compensation for with interest from date of accident.
Because you see, the authority can grant the claim prior to moving the tribunal.
Yes, my lord. In my my lord, in my claim application, I have prayed for interest from date of accident. You know, in this case, which I have stated, Ranchi High Court judgment. Kindly come to page number 14 of the judgment, my lord. I have quoted Supreme Court judgment of Reena Devi. So according to Reena Devi, this is a judgment. In view of the observation of the Honorable Supreme Court in the case of Reena Devi, the applicant are entitled for a compensation of 8 lakh along with interest at 9% from the date of incident.
So these are the two grounds regarding interest and regarding principal
amount. That is the fixed statutory compensation of 8 lakh. But due to this gross negligence, it has been awarded 5 lakh, man.
Yes, yes. What
negligence from advocate, not applicant.
Yes.
Who will suffer? Can you see page 123, paragraph 8.1? 120. 8.1. That I am reading. As per provision of Part 1 of Rule 3 of Railways Accidents and Untoward Incidents Compensation Rule 1990, for the death of victim, compensation amount will be 8 lakh. In the claim application, the applicants have claimed compensation of rupees 5 lakh for the death of the victim. We cannot go beyond the pleadings of the applicant. As such, we are inclined to allow 5 lakh as compensation in this case. No, he paid 5 lakh. What can be done? He may be entitled for 1 crore, but he is paying 5 lakh. 5 lakh already been granted. So what wrong in it?
My lord, as per statutory compensation is 8 lakh. That was my mistake. So for that, within 30 days, I filed a review petition also, and my review was dismissed.
Yes, apart from this, any other grounds?
No, not only this ground.
That's all? Yes, record an order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for orders on 28/1/2026.
Much obliged. My lord, it was the gross negligence of the advocate, not the applicant, my lord. Why will they suffer, my lord?
কটা আছে এই applications? Fixed matter to 2 p.m. Part matter PM এ তো একটা ম্যাটার আছে PM আছে
Much obliged.
But in the second half, your lordship is having a number of fixed matters, and there is 3:30 today also.
So it may not be possible to take up further claim cases.
Before rising as item number 43 of today's list, my lord. This is the assigned second appeal, my lord.
Yes.
Is appealing for the first date, my lord. I am appealing for the appellant. If my lord fixes a date, I shall serve notice to the other side. The suit of 1992.
You are for the appellant.
I am for the appellant.
It is ready for
Kindly
hearing.
passes an order so that
It's better let it be brought as to be mentioned tomorrow, and thereafter you
if
inform
my
the.
lord passes an order, I shall serve notice to the other
No,
side.
no, let it appear to be mentioned. So in the presence of the other party, I can fix a date.
My lord, regarding item number,
দিয়ে দেবেন এই।
my lord, regarding item number 42, today's interim order has been expired. 42.
Your Lordship, item number 45.
My lord, my lord, let it be fixed on tomorrow, my lord.
Interim order
Last two occasions,
January.
they took time. Mediation failed. My lord, this is a purely civil dispute in nature.
42, not today.
Your Lordship, I am seeking
Tomorrow,
2 weeks
take your chance tomorrow.
Tomorrow,
because we
my lord, there is no question of opposition.
submit one.
Yes, record an order. Yes.
Your Lordship, I am seeking
My lord, till dispose of the rest.
For the
opposition
learned advocates for the parties are present. Learned advocate for the opposite party prays for time to file affidavit in opposition. Let this affidavit in opposition be filed within 2 weeks. Reply, if any, within 1 week thereafter. The interim order granted earlier shall
Disposal of this
continue for a period of 6 weeks or till further orders, whichever is earlier.
I'm grateful.
Number
Judgment item number 1.
You are for the appellant
Appellant.
insurance company. Yes. Reading out the operative portion.
Mm.
Thus, this appeal FMA 935 of 2025 and COT 145 of 2025 stands dismissed. Judgment and award dated 21st December 2024, passed by Learned Additional District Judge, Second Court, Tomluk, Purbo Mendinipur in MSC case number 123 of 2012 is affirmed. However, the direction to pay 6% interest in the event payment is not made within 1 month from the date of the award is set aside. The claimant respondent number 1 will be entitled to withdraw the awarded sum along with interest at the rate of 4% per annum from the date of filing of the claim case till date of deposit.
And Lordship, the remaining amount will be refunded back to
Yes.
the insurance company.
So you have deposited as per 6%.
As per 6%.
So
Lordship.
that is set aside 6%. 4% the claimant will be entitled.
Will be entitled, he will withdraw and
Okay,
the
the
remaining.
balance amount, yes. The residuary amount, if any, will be returned to the
Insurance.
appellant insurance
Appellant.
company.
Lordship, along with accrued interest thereon.
Yes, whatever it is. As I have
No,
recorded.
no, already they have deposited the awarded amount, so the amount lying in the Registrar General, so the some interest has been accrued. So kindly awarded that the accrued interest thereon.
I have recorded that from 4% per annum from the date of filing till date of deposit. I've recorded that.
And Lordship, kindly one thing, there is a 6% usually Lordship allowing the all courts of the all coordinate bench Lordship was allowed. Now it reduced 2% also. Kindly 6%, kindly allowed 6%. So all the bench, all the also praise the judgment to that extent.
No, no, but this question here is not usual 6%. Here is penalty 6%. That I have set aside.
No, Lordship, usually Lordship granted 6% at least.
But this is here the trial court has already granted 4%. Okay.
So I have a cross objection to that effect.
Anyway, that I have not accepted.
6% usually. Otherwise, Lordship, some conflicting judicial opinion, Lordship. All the bench always consider 6%. Lordship, that is my humble submission. All the bench, all.
In other cases, I considered that, but this cases as because
Lordship, ultimately, all the honorable judges are decided 6% is standard interest. Lordship can verify my submission in the other lawyers, insurance company lawyers are present in Lordship's court. So all the other bench in equal all cases 6%, all cases.
I have come across cases where 4% is already awarded. Okay, there are cases where 4% is awarded. So I have not altered that. Only the penultimate, that penalty that if they fail, then I have set aside.
Lordship, I am agreed with that. The penalty should not be. That is the according with law, penalty cannot be. But Lordship, 6% Lordship in all bench. Lordship, if Lordship kindly direct me, I can place the various judgment. Last judgment also, Justice Bandopadhyay also decided 6% is the standard.
Okay, 4% is not unreasonable. Okay, that's why I have directed. Yes.
Lordship, this claimant is suffering, Lordship. They are 6%. All the claimants are getting 6%. Other matter they are getting 6%, but this claimant not getting. So it's 2%. I am not Lordship. Kindly injury case.
So just claimant will get some money, nothing more that. This is not the, I'm not bargaining, Lordship. I'm not bargaining. But Lordship, can you verify my submission? All the cases, Lordships and other coordinated by 6%. Well, can it's only, this is my humble submission, nothing more, Lordship. Nothing more.
There are other cases where I've seen 4%. 4% is not unreasonable. That is the discretion of the court. Yes.
I oblige to Lordship. I oblige to Lordship. I oblige to Lordship. Lordship, accrued interest there on, kindly mention this. Some interest because of some matters lying in the bank sector. So the some interest has been accrued. Kindly use the word accrued interest there on.
That will be reflected.
Lordship.
Yes.
Lordship, I appear for the Union of India in this.
I am for the appellant. My lord, my case is this, that the victim traveling from Baharampur to Barakpur by Lalgola Sialda passenger on 25/7/10.
Yes. Yes.
Actually, he was traveling by Lalgola passenger up to Lalgola Sialda passenger on 25/7/2010 to pour water on the Lord Shiva. And as per police report also, he was in Gerua, wearing his Gerua cap. And unfortunately, within Krishnagar and Badkulla, he fell down from the running train and died on the spot. Thereafter, station master gave the diary entry to the police, and police went to the spot. Police gave total report, which may please be
Yes.
First inquest report was done 20A, page 20A. 20 and 20A. Type copy
20A is the inquest report.
Inquest report. আজ 26/10 থেকে আমি সঙ্গে নির্বাচনে দুইজন রেগুলার রাজ্য থেকে সংগ্রহের ঘটনাস্থ পোস্ট নম্বর এত পাশে সাক্ষরের সামনে ওনাদের শনাক্ত মতন মৃত ও মৃত স্বামীকে মৃতদের সুরক্ষার রিপোর্ট প্রস্তুত করতে প্রবৃত্ত হইলাম। সকাল 7 ঘটে মৃত ব্যক্তিকে আপ ও ডান লরির মাঝে অর্ধান্বিত রক্তাবস্থায় পড়ে থাকতে দেখলাম। মৃত ব্যক্তির মাথার চুল কালো, ছোট করে কাটা, মুখ চোখ বন্ধ, উচ্চতা 5 ফুট 5 ইঞ্চি, গায়ের রং ফর্সা, দেহের বিভিন্ন স্থানে ক্ষত চিহ্নিত, ছেড়ে যাওয়ার চিহ্ন, গায়ের রং ফর্সা, দেহের সঙ্গে সংযুক্ত হাত ছড়ে চামড়ার সঙ্গে ঝুলন্ত অবস্থায় দেখা গেল। অন্যান্য স্থানে ক্ষত চিহ্ন দেখা গেল। ডান পায়ের নিচে দিয়ে গোড়ালি ভেঙে কেটে ক্ষত অবস্থায় দেখা গেল। হাঁটুর কাছে ক্ষত চিহ্ন দেখা গেল। মৃত ব্যক্তির গায়ে গেরুয়া রঙের গেঞ্জি, পরনে সাদা হাফ প্যান্ট, হলুদ রঙের জাঙ্গিয়া। মৃত ব্যক্তির পরনে হাফ প্যান্টের পকেট হইতে একটি রেলের টিকিট পাওয়া গেছে, যাহার নম্বর 808083178103 103-178, dated 24/7/2010. Actually, train started on 24th. যা পার্শ্ববর্তী ব্যক্তিগণের সামনে সিজ করা হইল।
Yes.
মৃতদেহ ডেথ মারফত এবং 573 নেতাদের নিকট কনস্টেবল প্রয়োজনীয় কাগজপত্র সঙ্গে নিয়ে শক্তিনগর হাসপাতাল মর্গে প্রেরণ করলাম ক্ষত সঠিক কারণ জানার জন্য পোস্টমর্টম করার জন্য। সাক্ষীগণের মতো ঘটনার দিন মৃত ব্যক্তি ট্রেনের দরজার সামনে বসেছিল, হঠাৎ চলন্ত ট্রেন থেকে পড়ে যায়, ফলে মারা যায়। দিস ইজ দ্য ইনকোয়েস্ট রিপোর্ট। পুলিশ অফিসারের মন্তব্য, প্রাথমিক তদন্তে জানতে পারলাম মৃত ব্যক্তি ঘটনার দিন চলন্ত ট্রেন থেকে পড়ে যায় এবং পরে মারা যায়। Now, may Lord please come to final report. 21A. Sorry, 21. First.
24.
24. Twenty-four.
24A.
Type copy 24A. The fact of the case in brief is that on 26/2006:45 hours, ASI Krishnagar received one railway memo from message number between Krishnagar Station Kharagpur City Junction and Badkulla. An untoward incident has happened at kilometer port number 97/18 in between LC gate number 66T and 63E, as reported by driver with AQ dead body lying inside up and down line. On basis of the railway memo, this UD case number 20/10 dated 26/7/10 has been started, duly endorsed by the OC being JRPS. I took up inquiry the case as per endorsement. I took up its inquiry and myself along with C50 Najuddin Sheikh and 2 Dome by ABR from Calcutta post number 25A. For its inspection. During inquiry, I came to know from the passenger Binay Haldar, Benu Haldar, and Bhakpuri Post, Baharampur district, Musa Somnath Haldar, and identified the dead body of Amrita Paramanik, aged 30 years, son of Sri Bindavan Paramanik, of village Belpukur, Post and Balarampur, PS Baharampur, district, Murshidabad. I took a photo of the dead body in presence of the witness, sent the dead body Krishna Hospital to know the actual cause of the death, directed necessary with all concerned papers of report. DMO during inquiry, it was learned by me that the deceased was fall down from down 112 Lalgola passenger 10 at about 1:15 hours. Also seized one railway ticket from the possession of the deceased from BPS. It will be BPC, Baharampur Court Railway Station to Barakpur Railway Station. Received came number at the duly Krishna Hospital. Dr. Ajit Kumar is reported death is due to shock and hemorrhage resulting from above mentioned injuries, which are antemortem and seem to be accidental in nature. I consult the OC. He suggests me to submit FRP over this case. There is no foul play behind that. It is an accidental death. So I FR over this case. This is the case, my lord.
Lordship,
Now,
Yes.
you please go to the judgment. Totally error, with full error, because ticket was seized. The question that has been asked, why the claimant has not produced the ticket? How the claimant will produce the ticket when the ticket
let
has
us
been
see the
seized by
judgment.
the police?
Let us see the judgment.
Page 7, Your Lordship.
The body was identified by whom? The body, the dead body, was the body handed over to the relations?
No, no.
No, no.
Relations.
The body after
But
postmortem was handed over to the relations, along with the certificate, death certificate and report.
Yes, sir, all these things. Otherwise, how they will carry from Krishnagar to Baharampur?
Yes. Because the funeral and all things were
at Baharampur.
And it was handed over.
Your Lordship.
Yes.
Today, that ED matter in court number 5, Your Lordship might be aware. There was a notification to that respect, Your Lordship.
Yes.
The ED matter, Your Lordship,
Okay.
in court number 5. Lordship, that has been taken up. Only the parties are allowed, Your Lordship. I'm representing the union in that, Your Lordship. If Your Lordship grants me kind leave.
So, you want a time?
Yes, Your Lordship. If it can be any short date.
Anyway, let him complete. Thereafter, on the next day, you submit.
Very well, Your Lordship. So I shall, Your Lordship, give in my appearance and leave.
Yes, yes, yes.
Okay. If Your Lordship so permits. Obliged.
So, what are the grounds of your challenge?
Challenge.
That is the ticket and the name technicality of name.
Police report, as per CRPC 174, police is the only authority to find a cause of the death. Police totally declared ticket was seized and fell down from that train. No question is there. Nobody, other body has said. Police has said. And it is a beneficial piece of legislation. And so many judgments is here. I have come with all these judgments here also. Unfortunately, she has not got opportunity to read it or heard it. Regarding name, recent judgment, my lord, recent judgment. Omrit and A was added. Police added A. Party did not add. Regarding Supreme Court's latest observations, my lord. 42 and 43, para 42, 41, 42, 43. July 2024. The evidence produced before the tribunal by the appellant to indicate that his parents had been resident in India much prior to 1/1/1966, whereas his siblings and himself much prior to 25/3/1971 has been disbelieved only on the ground of mismatch of actual English spelling of the names and discrepancy in dates. As far as the discrepancy in dates and spellings are concerned, we are of the view that the same are minor in nature. Variation in name spelling is not a foreign phenomenon in preparation of electoral bill. Further, the electoral roll has no acceptance to eyes of the law insofar as proof of the date of is concerned. A casual entry by enumerators when noting entering the names and date of birth is also the addresses of the persons while making preparatory surveys for the purpose of preparing electors cannot visit the appellant with dire consequences. Moreover, in our country, sometimes a title is prefixed or suffixed to a name such that the same person may be known also by one or two alias. The tribunal seems to have totally oblivious of all this. The state of Assam, as per the rate with female sex, Moreover, name 42 names of people. The statement as per relevant part is this. Moreover, names of persons which are written either by persons preparing the voter list or by the person making entries into different government records. The spelling of the name based upon its pronunciation may take on slight variation. It is not uncommon throughout India that different spellings may be written in the regional vernacular language and in English. Such and same person will have a differently spelled name in English and the local language. Omrit, his name was Omrit, son of Binaman Shah. Totally, police report is there. Address is same. Now they are raising the question why Omrit and Omrita. Police has written that T with A added. Unfortunately, they added A. Now it has come to Omrita, but his name is Omrit Paramani. So, father's name is matching, address is matching, death certificate is matching, postmortem is. Now they are raising all these questions. This is totally not only this. What is the purpose of this idea legislation? Purpose is expression, not come to the literal expression. This is a beneficial piece of business. Now I come to this judgment, my lord. This is the Pobhakar Vijay Kumar judgment. Landmark judgment of Honorable Supreme Court. So many observations is there. Only I reading only, my lord, 2 or 3 observations.
Page
Para 13, page 3. Hindustan Liver Limited versus Ashok Vishnu Kate and others. Menu Supreme Court 2019. Court observed.
Yes.
In this connection, we may usefully turn to the decision of this court in Workman's vs. American Express International Banking Corporation, wherein Chinnappa Reddy's judiciary in para 4 of the report has made the following observation. Honorable Justice Reddy's observation. The principles of statutory construction are well settled words occurring in statutes of liberal import, such as social welfare legislation and human rights legislation, are not to be put in Protestant beds or sung to Lilliputian dimension. This is very voiceful expression. Human rights legislation or social welfare legislation are not to be put in Protestant beds or sung to Lilliputian dimensions. In construing this legislation, the imposer of literal construction must be avoided, and the prodigality of misapplication must be recognized and reduced. Judges ought to be more concerned with the color, the content, and the context of such statutes. We have borrowed the words from the Lord Wilberforce's opinion in Pennington Simon's case. Pennington versus Simons. In the same opinion, Lord Wilberforce pointed out that law is not to be left behind in some island of literal interpretation, but is to inquire beyond language, unisolated from the matrix of facts in which they are set. The law is not to be interpreted purely on internal linguistic consideration. In one of the cases cited before us, this is Surendra Kumar Verma versus central government, industrial tribunal come labor court, we had observed to say this observation. Semantic luxuries are misplaced in the interpretation of bread and butter statutes. Welfare statutes must, of necessity, receive a broad interpretation. where legislation is designed to give relief against certain kinds of mischief. The court is not to make inroads of making etymological excursions. Francis Bennett, in his statutory interpretation, second edition, has dealt with the functional construction rule in para 15 of this book. The nature of purpose of construction is dealt with para 20 at page 60 last. A purposive construction of an enactment is one which gives effect to the legislative purpose by following the literal meaning of the enactment, where that meaning is in accordance with the legislative purpose. In this code called a purposive and literal construction, or applying a strained meaning where the literal meaning is not in accordance with the legislative purpose. In the code called a purposive and strained construction. At page 66 of the same book, the author has considered the topic of purposive construction in contrast with the literal construction. The learned author has observed as under contrast with literal construction, although the term purposive construction is not new, its entry into fashion betokens a swing by the appellant courts away from literal construction. Lord Diplock said in 1975, if one looks back to the actual decision of the House of Lords on question of statutory construction over the last 30 years, one cannot fail to be struck by the evidence of a trend away from the purely literal towards the purposive construction of statutory provision. This matter was summarized by Lord Diplock in this way. Lord Diplock in this way, his observation. I am not reluctant to adopt a purposive construction where to appeal the literal meaning of the legislative language. I am not reluctant to adopt a purposive construction where to apply the literal meaning of the legislative language used would lead to results which could clearly defeat the purpose of the act. But in doing so, the task on which a court of justice is engaged remains one construction, even where this involves reading into the act words which might expect be included in it. There are para 14, my lord. In our opinion, if we adopt a restrictive meaning of the expression accidental falling of a passenger from a train carrying passenger in section 123C of the Railways Act, we will be depriving a large number of railway passengers from getting compensation in railway accidents. It is well known that in our country, there are crores of people who travel by railway train, since everybody cannot afford traveling by air or in a private car. By giving a restrictive and narrow meaning to the expression, we will be depriving a large number of victims of train accidents, particularly poor or middle class people, from getting compensation of the Railways Act. Hence, in our opinion, the expression accident falling of passenger from a train carrying passenger includes accident when a bona fide passenger, that is a passenger traveling a valid ticket or pass, is trying to enter into railway train or falls down from the process. In other words, purposive and non-literal interpretation should be given to this expression. Para 15, section 229 of the Railways Act defines passenger means a passenger traveling with valid pass. Section defines untoward incident to include the accident falling of a passenger from a train carrying passenger. Section 124A of the Railways Act, which are concerned states. 124 is the part of the compensation. Untoward incident definition 123 BC provision, and 124A is the compensation for untoward incident. Whereas the act, when in the course of working of a railway, an untoward incident occurs, then whether or not there has been any wrongful act, neglect or default on the part of the railway administration, such as would entitle passenger who has been injured or the dependent of a passenger who has been killed to maintain an action, recover damages in respect thereof, the railway administration shall, notwithstanding anything contained in any other law, be liable to pay compensation to such extent as may be prescribed, and to that extent only for the loss occasioned by the death of or injury to a passenger as a result of such untoward incident.
So prior to lodging claim before the tribunal, is there any provision that you have to lodge a claim or make a representation before the authority?
No, actually, rule is there. Any untoward incident.
No, in the form, does it prescribe that?
No, form that is not prescribed.
Yes, but does the statute
But
say
any
that?
untoward incident happens, there's a provision. Ex gratia provision is there.
Yes.
They may claim to the railway for ex gratia, but ex gratia part another and compensation. Compensation cannot directly given by the railway. Compensation has to be passed by the award of the railway claims tribunal.
Okay. So it cannot be granted by the railway authority.
No, directly not. Only ex gratia can be granted.
Ex gratia. Ex gratia also under the Railway Act.
Railway Act is rules, not Railway Act.
Yes, railway rules.
Actually, my lord, my case is very clear. Name is not the factor as the Supreme Court decision. And this, now I am writing other, what is the purpose of this act that has been, the exception is there, suicide, attempted suicide, my lord, by him, that 124A, which
Yes.
is reading. Self-inflicted injury, his own criminal act. Or any act committed by him in state of intoxication or insanity. Any natural cause or disease or medical or surgical treatment, unless such treatment becomes necessary due to injury caused by the said untoward incident. These are the exceptions. Passenger definition is a railway servant on duty, a person who has purchased a valid ticket for traveling by a train carrying passenger on any date or a valid platform ticket or becomes a victim of an untoward incident. But that has been declared by this act. What is the purpose expression of that? What is the purpose of the act? It is a beneficial to give the welfare to the victims, not with the Lilliputian idea that this is not, that is not, that should not be. This is the expression of the Supreme Court. Many judgment is that being expressed, but this is the best judgment of the expression. So many judgments. My lord, may please, I am not reading all this 34, para 34, para 30, page 9 of this judgment.
Yes.
My lord, 41, para 10, page 10, 41. This is very important para to get it considered.
Yes.
This is Railways and Ferences. If case was there, that is a provision of thus observation of Railways and feature. It is true that attempts to apply the principle of Railways and feature against public bodies have not on the whole succeeded by the administrative law by P.P. Gert, second edition P.46, mainly because of the idea that a body which acts not for its own profit but for the benefit of the community should not be liable. That was the idea. However, in our opinion, this idea is based on a misconception. Strict liability has no element of moral censure. It is because such public bodies benefit the community. That is unfair to leave the results of non-negligent accident to lie perpetuously on a particular individual, rather than to spread it among the community. If the loss occurred to a person, you please spread it to the community when it is serving for the benefit of the community. so that one person should not bear the loss. That is the idea. 44, my lord. In our India, Article 31 of the Constitution states, the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, political, and inform all the institutions of the national life. This is the Constitution 38(1) para. That is the constitutional part. So we are the welfare state. 45. That it is the duty of the state under our constitution. This is the judgment, very good judge, Prabhakar Vijan Kumar.
In case of strict liability.
Whether any fault on the part of the railway or not, whether that is actually going to the strict liability. That has been expressed. That has also been expressed by this law.
Because you see, whenever some accident occurs, the railway authority themselves also conducts inquiry. From their
That has not got it. That is the divisional report, DRM's report.
Yes, because something has
That
happened.
has not been. I have given in my applications that appeal. This has been actually given the
So
point.
if they conduct an
Divisional railway managers report, DRM's report, that has been submitted.
So that was not done or not submitted?
Not submitted as well, really. Most probably not done. Or if it is done, not submitted because the police fact findings.
Because that is an internal inquiry.
That must have been. And that should have been, that must have been produced before the railway comes tribunal. As per rulings is there, the issue of railway comes tribunal.
So suppose DRM finds that yes, this is an accident.
My lord.
So, but the railway authority cannot ascertain the claim.
Yeah.
The quantum.
Actually, that is the internal, so many claims are coming. That's why railway told, actually, this is an internal function. And actually, as a rule, it comes in railway comes tribunal that railway itself will prepare a divisional railway managers report, DRM's report. That will be conducted by the RPF. And that will be submitted to the DRM for approval. And that will be submitted to the railway constable for their appraisal of the facts. Most probably, my lord, they have not prepared it, or even if PT had not submitted it because of the GRP's report. It's a fact. Actually, he was coming to pour water on the Lord Shiva. That was a Saban Mass. He was coming to the ticket. Ticket was seized. And he was unfortunately pregnant because 110 is there. And that is Roibar. And most probably Sombar was the date of pouring water on the Lord Shiva. And that was huge rush.
Lalgola passenger.
Lalgola passenger.
Up to Barakpur.
Up to Barakpur. He fell down and ticket seized. How will give the ticket? Why that tribunal did not ask the police person to authority to come in to give
the seizure list.
Seizure list. Come with the seizure list. Why they did not ask for it?
Because as per the report,
am I responsible for that?
As per the report, the ticket is there.
Ticket seized.
Seized.
So, my lord, when it is seized, it was the money actually was the duty of the tribunal to summon the police person to come with seizure list along with the final report. But they did not do it. Now asking my evidence, why the person will come to me? There, actually, my case was closed. Even I have the evidence, case was closed. Police person was not called for, so the police report is very...
The railway authority did not adduce any evidence.
Did not adduce any. Did not...
Did they file any report?
Only written statement did the place and did not collaborate any evidence, did not ask any evidence, did not question the ticket also. They did not actually query about the ticket, whether the ticket has been issued from the Baranpur court to Barakpur or not. Not done. My lord, just I want to give another judgment. That is the last judgment passed by the Honorable Supreme Court. This is actually summary of the judgment. Sir, this is the last judgment and club judgment, summarized judgment by the Honorable Supreme Court in Rina Devi's case.
Yes.
So many judgments have been discussed here with all conclusion to get it concluded. Para 15 is there. We now proceed to deal with the following issues. Say whether the quantum of compensation should be as per the prescribed rate of compensation as on the date of the application, incident, or on the date of order awarding compensation. That is the quantum compensation. 15.1. 2. Whether principles of strict liability applies. 3. Whether presence of body near the railway track is enough to maintain a claim. 4. Rate of interest. Now, this has been discussed. 15.1. Quantum of compensation. Page 13.
Quantum is prescribed under the rules.
Rules is there, but actually 1997 it was 4 lakhs. 17 it has come to 8 lakhs. So many cases has been pending from 14 to 17, 20 pending matters. So how the compensation will be decided? Whether 4 lakhs or 8 lakhs.
Or from the date of the injury or from the date of the award?
No, that date of the injury, that is not the question. How the 4 lakhs was there and now it has come to 8 lakhs. So many cases are pending at the tribunal or the Honorable High Court or some Supreme Court. Actually, that case happened in the year 2012. On that time, it was 4 lakhs. Now, case has to 16 or 17 is going to be awarded. So, what will be the compensation? So many expressions there. Now, Rina Devi has concluded. Rina Devi has concluded so many judgments, so many 15.4, page 17.
You are not challenging the quantum, simplicity challenging. There is no question of any quantum.
Quantum is coming, my lord, because my accident happened in 2010. Now it is 25. 15 years lag between the poor lady, widow lady suffering with his only one son. And she has tried my level best to grow up his son. Now she is educated, she is something earning. 15 years she has lost.
Okay, now the question is, what does this judgment say regarding the award?
Award 15.4. Actually, so many complications arises because 4 lakhs and 8 lakhs. Because the pending of so many cases in different forums and courts. That's why the Honorable Supreme Court has concluded it. Accordingly, my lord, page 17.
Yes.
15.4. Accordingly, conclude that compensation will be payable as applicable on the date of the accident with interest as may be considered reasonable from the time to time on the same pattern as accident claim cases. If the amount so calculated is less than the amount prescribed on the date of the award, tribunal, the claimant will be entitled to higher of the two amounts. This order will not affect the awards which have already become final and when limitation of challenging such awards has expired. This order will not by itself be a ground of condition of delay, retiments, and Kalani Charan Sahu stands explained accordingly. The 4-judge bench, Pratap Narayan Singh holds the field. The subject and squarely applies to the present situation. Compensation is applicable on the date of the accident, has to be given with reasonable interest, and to give effect to the mandate of beneficial legislation. If compensation as approved on the date of award is higher than the unrevised amount with interest, the higher of the two amounts has been. Unrevised amount with interest, if it is come to 8 lakhs, not come to 8 lakhs, it will get 8 lakhs. But if it is comes above the 8 lakhs, higher amount has to be given. Unrevised award with interest, if it comes to below 8 lakhs, the claimant will get 8 lakhs.
That is the statutory amount.
That's the statutory amount at present. 8 lakhs.
At the date of passing of the award.
That is, my lord. But if it comes to exceed 8 lakhs for the delay,
Yes.
that amount has to be given, whichever is higher. This is the sir, compensation regarding application of principle of strict liability. So many judgment has been discussed here and elaborately written here, but I am going to the conclusion of this part. (16.6), page 23. This is the explanation of the self-inflicted injury. My lord, we are unable to uphold the above view as the concept of self-inflicted injury would require intention to inflict such injury and not mere negligence of any particular degree. Doing so would amount to invoking the principle of contributed negligence, which cannot be then done in case of liability based on no fault theory. We may in this connection refer to a judgment of this court, United India Insurance Company Limited versus Sunil Kumar, laying down that plea of negligence of the victim cannot be allowed in claim based on no fault theory under section 163A of the Motor Vehicles 1988. What is the provision 163 of 1948?
Yes, that's a no fault liability.
That has been applicable here also. This is the conclusion. We hold that death or injury in course of boarding or deboarding of a train will be an untoward incident entitling a victim to the compensation and will not fall under proviso of section 125 merely on the plea of negligence of the victim as a contributory factor. Merely negligence is not will be contributory in deciding all these cases. Third, my lord, burden of proof when body found on railway premises, definition of passengers. So many definitions is there, so many judgment is there. I am going to the concluding part of this judgment, that is page 27, 17.4. What the Supreme Court holds by this judgment? Honorable Supreme Court holds by this. Matter 17.4. We thus hold that mere presence of a body on the railway premises will not be conclusive to hold that injured or diseased was a bona fide passenger for which claim for compensation could be maintained. However, mere absence of a ticket with such injured or deceased will not negative the claim that he is a bona fide passenger. Initial burden will be on the claimant, which can be discharged by filing an affidavit on the relevant facts, and burden will be shifted on the railways, and the issue can be decided on facts shown on attending circumstances. My circumstance is very clear. No ticket, question of ticket lost or nothing is not. It is not a question. But I am reading this para also because what is the aspect of this law? What is the aspect of how it has to be considered? Even the dead body found in the railway line, and if it is claim means I am giving the affidavit with claim. This is my claim. That is also affidavit. Really has to prove that he was not a passenger, he was a stressed person. That point has to be taken into consideration also. Facts and circumstances. Some person residing in Murshidabad.
So there may be oral evidence with regard to that.
My lord, some person residing in Murshidabad, accident happened at Krishnagar or Barakpur. How he come as a trespasser from Krishnagar to Murshidabad to Barakpur as a trespasser?
No, the question here is with regard to the non-availability of the ticket. Suppose the
Non-available.
ticket could not be seized.
Now, tickets, this is my question.
That is a
Question
separate issue.
My question clear, case is very clear. Rate of interest, my lord, that is the last para. That must be, it is not applicable right now. Interest has to be there 6% from the date of application till the date of award, 9%. And 9% rate of interest was awarded from the date of award. The rate of interest has to be reasonable at par with accident given. We are of the view that in absence of any specific statutory provision, interest can be awarded from the date of accident itself when the liability of the railways arises up to the date of payment, without a difference in the stages. Legal position in this regard is at par with the cases.
No,
of
liability
accident.
of the railway arises from the date of the accident
From the date.
to pay the compensation.
That is the concluding part of Honorable Supreme
But
Court.
the compensation cannot be paid unless it is adjudicated by the tribunal.
But this is Supreme Court's order, my lord. This is Supreme Court's order. I am not telling. This is Supreme Court's order.
No, anyway, can means discretion, can be granted.
No, sir. We are of the view. We are of the view
Interest can be awarded.
that in absence of any specific
Yes,
statutory provision, interest can be statutory provision. There is no statutory
Okay,
provision.
can be awarded is one thing and shall be awarded. Shall be awarded means you have
Shall
to
be awarded means other things, and can be awarded the other things. Shall be awarded,
Courts are-
it may be or not be. Can
No,
be.
no, shall is a mandatory provision. And can be means courts empowered.
Maybe not, sir. Can be.
Can means courts are empowered. Court has
That
discretion.
is the Honorable Supreme Court decision.
Yes, one is the court having discretion, the other is
Actually,
court.
we are guided by the Honorable Supreme Courts. Where this is our highest mandir. We cannot go against that. So this is the Supreme Court judgment. They have actually expressed their idea with this fashion. Can be means there may be. Can be means may. Can is greater than may. As per English language, may go and can go. That is different. May go mane may not go or may not. But can go mane ami jane. So pari mane part to lower courts pari from the date of accident. From the purpose. Then my question is this: sir. My accident happened in the year 2010, and that lady, and I am well-wisher of that lady, running from this to this bench for the justice, and she is actually not got the justice as deserved. So she is suffering from 2010,
Right.
and her husband came to pour water, Lord Shiva. Is it her punishment? And you, my lord, you please see, she was wearing a gerua. So it will be double punishment.
Anyway, you want to conclude on the next day or let
If
us?
you give me a chance, I will conclude it next day. My conclusion is there. I don't want to go exceeding Honorable Supreme Court. I don't want to go exceeding Honorable Supreme Court. When the Supreme Court judgment is there, that is my conclusion.
Yes, learned advocates for the parties are present. Learned
Vijay judgment,
learned advocate for the appellant submits but could not conclude the same. Let this matter appear on 20. দেখুন তো 20 তারিখে ইয়ে আছে কিনা 20 তারিখে
My lord, my for Vartmanti Kalika Puja will be celebrated at my home so on 17th, and I'll be 19th, 18th, 20th maybe, 20th maybe.
20 তিনটের সময় হবে না 21 হবে দুটোর সময় তো নেই ওকে 21/1/2026 at 2 p.m.
Obliged. But my lord, this is all a very good judgment to actually to be enriched by myself.
Yes, this welfare legislations.
We should be enriched.
Yes.
Otherwise, total justice, proper justice will not
With
be.
regard to welfare legislation, what should be applied?
What is the expression?
Yes.
Oh, my lord, this is the quantum of the compensation, 8 lakhs. That comes into effect 1927, 2017. That's why the complications have been arised.
Okay. Yes, call the 3 p.m. fixed matter.
3 p.m. 2 p.m.
My lord, I'm appearing for the respondent.
Yes. Mr. Mukherjee was arguing on the last occasion.
Lordship,
Well,
my lord, I sought Lord time from your lordship that about 1 hour time will be required to
So
conclude my
we have
argument.
half an hour today.
Half an hour. I'll try to my lord compress my argument. On the next day, I'll not cite the judgment that I'll be my lord relying upon. So, my lord, on the last occasion, your lordship may remember, my lord, this was a case where my learned friend filed the suit, my lord, for reasonable requirement, and my lord, other relief, it was dismissed. In the appeal court, it was reversed.
Yes.
The my lord, the appeal court was of the opinion that my learned friend's client, my lord, they required the suit property. Therefore, it was decreed only on the ground of reasonable requirement to accommodate, my lord, the
Managerial
employees of,
staff.
my lord, yes. My lord, the trial court disbelieved their case, and my lord, the appeal court, my lord, reversed that finding. Now, my lord, I have completed reading, my lord, both the court's judgment. Lord, your lordship will kindly come to, my lord, the PW1. Lord, I'm only, my lord, taking your lordship, my lord, to the relevant portions. Do your lordship have not that phone volume? Oh,
This is the second volume.
yes, the second, no, Lord, this is not the lower court records that is in volume number koto? 1. Yes.
No, this one.
Yes, lordship. Yes. আসলে আমার কাছে এটা পার্টের দুটো আছে আমার এখানে ভলিউম 1 ভলিউম 2 বলা আছে তাই 15 The lordship will kindly come to lord page number 15. But the cross examination of PW1 that starts from lord about 3 lines from bottom. Pages. এইটা হ্যাঁ হ্যাঁ The names of the other directors of the plaintiff company are Sunita Sancheti and Sampatmal Sancheti. Sunita Sancheti is my wife and Sampatmal Sancheti is my paternal uncle. Further cross-examination, the shareholders of this company are the members of my family, my uncle's family and others. 7 or 8 private limited companies have their registered office at 8 Kamak Street. I cannot name all the registered companies right now. Me and my own family members are not directors of those 7 or 8 companies. 3 or 4 companies are there where me or any members of my family is a director. Now, Lord, kindly skip over to about Lord, the middle of the page wherein Lord, it starts with Lord, it is fact that the office accommodation of the plaintiff's company at 8 Kamak Street was not inspected by the commissioner. Lord, about Lord, it is in the middle portion.
Yes.
Then your lordship will kindly Lord, third line from bottom. I am not aware of the existence of the company Mrs. Sanchiti Estate Private Limited. At present, Sanchiti Project Private Limited, which is a different company than Sanchiti Enclave Private Limited. It is running only one project at Rajarhat. Then, Lord, the next page, it is not much of importance, Lord, for our purpose, because we were trying to find out that they are a developer company. And on that context, Lord, the questions were put in cross-examination. Then your Lordship will kindly skip over to, Lord, page 18.
Yes.
I have filed this suit on the ground of reasonable requirement of the plaintiff. Not a fact that this ground of reasonable requirement has been manufactured and it is concocted story to evict the tenant. It is fact that I have stated in the plaint that the plaintiff requires the suit premises to accommodate Naveen Kumar Setia and Arun Kumar Bait, two employees of the plaintiff. Now, Lord, I pause here for a moment. Lord, this is a specific, Lord, a case of the plaintiff that he wants to accommodate two named gentlemen who are the employees. It is fact that I have filed the appointment letters of these two employees. Mr. Prakash Sharma has signed the appointment letter, Exhibit 15. Mr. Prakash Sharma is the authorized signatory of the plaintiff company. It is a fact that in Exhibit 2, Mr. Prakash Sharma has signed as director of the confirming party, Messrs. Rosewood Merchants Private Limited. Lord, this is where the collusion comes. Rosewood was, Lord, the company who was, Lord, a confirming party in the purchase deed of the plaintiff company. This is the exhibited document.
Anyway, this is also a factual aspect.
Yes.
Okay.
The factual aspect goes to the root about, Lord, the bona fide of the reasonable requirement. Because that is one of, Lord, the questions.
So it was considered by both the courts, this issue.
Yes. First court, the trial court, Lord, disbelieved. The suit was dismissed.
No, this issue regarding this collusion, it
Lord,
was considered.
Yes.
This point was raised also.
Yes. And before the appeal court, Lord, it was reversed. And I have read before your Lordship on the last occasion how, Lord, the appeal court dealt with the issues. Now, Lord, coming back, Lord, to how, Lord, the witnesses have dealt with this. Lord, this was the categorical statement of the plaintiff's witness. It is fact that Prakash Sharma issued the money receipt. Naveen Setia has accepted the consideration amount on behalf of Sudha Bait. Sudha Bait is the vendor of the plaintiff. It is fact that Naveen Setia, who is the constituted attorney of Sudha Bait, is the same person by whose accommodation the plaintiff company has filed this suit. It's categorical. It is fact that Prakash Kumar Sharma, who signed the appointment letter, is the same person who signed as confirming party on behalf of Rosewood Merchants Private Limited on the letter of conveyance Exhibit 1.
Yes.
Then, Lord, kindly skip over 3 lines. Not a fact that the legal license agreement Exhibit 16 and the rent receipts thereof have been manufactured for the purpose of the suit. Not a fact that the plaintiff as myself and its sister concerns deal with building construction in and around Kolkata. Not a fact that the sale of the suit premises has been effected on paper only for the purpose of filing of this suit. This was with an objection. Then, Lord, kindly skip over one sentence. Lord, then it starts with no flats are owned by the plaintiff at Nilkant building at premises number 26B Kamak Street, Kolkata 16. My father and myself are the owners of flat number 10B and 10C, Nilkant building. As on today, I do not know who is the owner of flat number 10D Nilkant building. Right now, I cannot say who was the owner of 10D Nilkant building at the time of filing of the suit. I am aware of the contents of my written examination in chief. On perusal of the paragraph 36 of the written examination in chief, the witness states that it is written that flat, it is within inverted commas, flat 10D was around by one Sanchiti Projects Private Limited. It must be owned by one Sanchiti Projects Private Limited. But during the pendency of the said suit, the said flat has been sold to Mr. Binay Kumar Bait. It is fact that I was one of the directors of Sanchiti Projects Private Limited. I cannot say the names of the other directors. I am one of the directors of the company, namely PS Group Realty Limited. I cannot say if Mr. Navin Setia was the director of Messrs. Rosewood Merchants Private Limited at the time of purchase.
On which page you are
No,
now?
the next page. Next page.
What is
Page
47?
that is printed page 20.
Inner page 20.
Yes, Lord. Yes. The
Yes.
47 ও লেখা আছে আসলে ওটা হাতে 47 লেখা আছে ঠিক আছে হাতে আছে
Yes, running page 47.
Lordship 47 and 20 also Lord that is in print. Then Lord, I am one of the director of the company, namely PS Group Realty Limited. I cannot say if Mr. Navin Setia was the director of Mrs. Rosewood Merchants Private Limited at the time of purchase. Not a fact that the transaction between Sudha Baid and Mrs. Rosewood Merchants Private Limited was a sham transaction. Navin Setia is an employee of the plaintiff company. Prakash Sharma is not an employee of the plaintiff company. Not a fact that I am the proprietor of Mrs. Rosewood Merchants Private Limited. Not a fact that I did not induct the tenant of the suit premises for residential purpose. Not a fact that I inducted defendant tenant in the suit premises for residential as well as for the purpose of doctor's clinic. It is fact that the tenancy agreement exhibit 9, it has been mentioned that the purpose of tenancy was residence and for the purpose of doctor's clinic. Therefore, it demolished, Lord, their other grounds as to change of user and all, which
Not
Lord,
residential purpose.
no, Lord, kindly then Lord, about Lord 10 lines from bottom. The sentence starts from I cannot say if Sancheti Projects Private Limited and the plaintiff company have common directors. At present, I am not a director of Sancheti Projects Private Limited. Not a fact that I am the exclusive owner of Sancheti Projects Private Limited. It is not a fact that Sancheti Projects Private Limited was the owner of flat number 10D. But during the pendency of this suit, the said flat was sold to one Binay Kumar Vaid. Not a fact that the said flat is still in possession of the plaintiff company and the said transaction is a sham transaction. I cannot say if at the time of inspection, the learned advocate for the defendant insisted upon inspection of the said flat number 10D. I cannot remember if 10D was sold before or after commission. Not a fact that I am deposing falsely. Then, Lord, this is Lord, all about PW1. The PW1, the important portion that I have pointed out about Lord at page Lord 45 equal to page 18, that is Lord the collusion portion in the cross-examination. Then comes Lord the evidence of Lord the PW2 at page 21, that is 48, handwritten 48. This is a lawyer's Lord who was appointed as Lord the commissioner. Lord, the cross-examination is very Lord, that is Lord at page, that page itself Lord about 6 lines. I was discussed to perform my commission work as per petition under order 39 rule 7. It is fact that I was directed to inspection of flat number 10B and 10C. Therefore, these are Lord the 2 flats. That is at Nilkant building. 10D was owned by another company of which Lord the plaintiff was a director. And Lord, the registered office that has not been inspected. The suit property was also not inspected.
No, suit property was inspected.
Not suit flat was not inspected.
No.
That is 1B.
No, regarding availability of the accommodation in other premises, was there any commission to that particular premises? Neither it was at the suit premises.
The suit premises had Lord the suit property. The suit flat is 1B.
Yes, yes.
And in that building, Lord, there were 3 flats. That is 10B, 10C, and 10D. 10D stood sold. So 10B and 10C, Lord, was owned by the director of the plaintiff and not the uncle of the plaintiff. In only those two flats were not the subject matter of commission, 10B and 10D.
Uncle of the plaintiff.
Uncle of the director of the plaintiff.
Director's father. It's like if I am a landlord, I have an uncle, he has a house, so the tenant says that is.
Well, it may not be that way, but Lord, I can relate that what Mr. Chatterjee says is correct. That Lord, he is a director of a particular company, and Lord, that his
Director of the
father
uncle, not director of the plaintiff.
yes, Lord, yes, the director's father. Similar, thanks for correcting me that way, because I understand. Now, Lord, that is, Lord, has been clarified in the cross-examination of Lord the plaintiff that I've already stated, Lord, and he is Lord the director of the plaintiff company, and he has stated there. Now, Lord, coming back, Lord, to the evidence of Lord. The defendants, not the evidence. But the cross-examination of Lord the defendant is at page 88. But we'll kindly skip over to Lord printed page 92. 92 printed page.
Yes.
But about Lord 8 lines from top, Lord, which starts from I said that the transaction is a sham transaction because Naveen Kumar Setia, who is one of the director of Rosewood Merchants Private Limited, acted as the constituted attorney of Sudhabai, the vendor, and he is also an employee of SN Alloys, the plaintiff company, and he is also one of the directors of the confirming party, which is Rosewood Merchant Private Limited. Voluntarily says Naveen Kumar Setia acted on behalf of the vendor and the purchaser at the same time. Naveen Kumar Setia is one of the directors of Rosewood Merchants Private Limited, and he was the constituted attorney of Sudhabai, the vendor, and he is an employee of the plaintiff company.
Now you see,
my lord,
your defense lies, whether it is a bona fide or not, that he has other accommodations. Okay. Now, here you want to build your case on the ground of collusion.
Collusion, bona fide of the requirement.
Bona fide requirement that this sale is an act of collusion or it's a sham transaction.
Yes, and to say that this was only affected because to seek a recovery of possession.
Question is this sale between this directors, one director and his relations, or one director and the another director?
No, this was, my lord.
Or sale is exclusively by this person with a third party?
The third party, constituted attorney, my lord, was found to be, my lord, related to the plaintiff company.
This third party?
Yes. Sudhabai was represented by a constituted attorney. The constituted attorney was, my lord, found to be the signatory of the appointment letters of, my lord, the two employees whose requirement has been sought for by the plaintiff.
No, that is a different issue. You seeking bona fide, seeking eviction on the ground of bona fide requirement. That is the case of the plaintiff. Your defense is that there are other accommodations of the plaintiff.
That is also there.
That is your case.
Yes.
Now, with regard to this collusion issue, okay, whether this sale transaction is not a gift, it is after all a sale. Now, the question of this sale transaction, was that your case, that the sale is effected just between director and employee, or one director and another relation of the director? Is it your case?
No, we did not take that case, my lord, to that level, because we tendered, my lord, rent to, my lord, the person who had purchased, that is the plaintiff as of today. But all that I...
No, the other accommodation, not the suit property. No question of suit property. The other portions of the director which was sold out.
Lordship. No, there, Lord, I did not take a point. Lord, I understand your Lordship says about the 10D which was sold out.
Yes, some is sold,
Yes.
the other is occupied by director or his relation or
Lordship,
whatever it is.
that is flat number 10D in that particular building, which, my lord, the witness, the plaintiff says that I cannot say whether it was sold before or after the suit was filed. That suit property was owned by not by SN Alloys but by another company where, my lord, the directors are common. In 10D, I am answering your lordship.
So that was not, so that with regard to your cross-examination, whether it was sold prior to the institution or thereafter,
So
that
my
was,
cross-examination is, my lord, on the suit property. This was on the suit property. That, my lord, the flat number 1B on which, my lord, the suit
was on the suit property, no commission was held.
No
This is an
commission was
admitted position. So question is, you want to build your case on the ground of collusion with regard to another property which is sold.
Lordship.
So you have to establish that it is exclusively between these relations and directors and all these things.
That
if
is
you are to
not-
succeed in that,
Lordship. But in that way, my lord, we have, my lord, produced, my lord, documents to say, I'll show before your lordship, my lord, the exhibits, where from your lordship will find, my lord, about the composition of the company and, my lord, when it was sold. The composition of the company,
that was exhibited.
that was exhibited.
And date of sale is, according to you, prior to the suit or during the suit?
But that I will just find out.
From
lord,
the exhibit?
From the exhibit. I'll find out. We take to.
That sale deed was not exhibited?
No, the sale deed was not exhibited. No. Take to back my sister. But I'll just try to, my lord, come on. Number exhibit 1 shown to the witness, and she states that Naveen Kumar Setia did not sign on behalf of Rosewood Merchants Private Limited in exhibit 1, but he signed on behalf of Shudha Baid as constituted attorney, and Prakash Sharma signed on behalf of Rosewood Merchants Private Limited. Exhibit E is shown to the witness, and she states that DIN, Director's Identification Number of Kamal Kumar Dugar, is such and such. Another document is shown to the witness and she states DIN is the same. Let the document be marked as Exhibit 25 on admission. I do not have any document to prove that the plaintiff company is not required to prove residential accommodation to the senior staff manager and assistant manager. But then your lordship will kindly skip over page 26. That is printed page 95.
Yes.
But about, Lord, 8th line, Lord, that is the first paragraph. I agree that SN Alloys and Sanchiti Projects
Page
privately.
25 or 26?
No, 26,
Yes.
printed 95.
Yes.
I agree that SN Alloys and Sanchiti Projects are different companies. Flat number 10D stood in the name of Sanchiti Projects Private Limited. Here the plaintiff is SN Alloys. Then, Lord, printed page 99. DW1 produced, Lord, net copy of Ministry of Corporate Affairs, which is marked as Exhibit K, K1, K2, and K3. These are, Lord, the composition of the company, the director is, Lord, the position. Then, Lord, at page 103, the printed, Lord, 103. After my cross-examination was closed, while perusing the documents, I found that Mr. Naveen Setia had mentioned his residential address as 8 Kamak Street, Shantiniketan building, 5th floor, room number 3A. So I searched the net to find out whether the same was mentioned in his other documents or not. The office address of Sri Vinayak Villa Private Limited and Khazana Tie-Up Private Limited is at 8 Kamak Street, 5th floor, room number 3A. It is a fact that Mr. Setia is one of the directors of both mentioned companies. I know Shantiniketan building. I cannot say if Shantiniketan building is used entirely for commercial purpose. I do not think that Mr. Setia uses the address as 8 Kamak Street for the purpose of correspondence only. It is a fact that the residential address and the office address of Mr. Setia is the same, and that is 8 Kamak Street. I do not have any personal knowledge whether Mr. Setia resides at room number 3A, 5th floor, Kamak Street, which is his office address also. But the cross-examination was concluded. Now, my lord, on the last day, appointment letter. Your lordship put a query to me as to not the requirement of not providing accommodation not to these two named employees of the plaintiff company. Lord, your lordship was pleased to ask me whether they are residing at Kolkata or not outside, so their the accommodation was required to be provided for by the employer. Lord, there are not two exhibits which are not of importance. That is not exhibit E15. That is exhibit 15 at page 61. 61 at our volume কত? Lord, this will be from Lord. এটা ওখানে আমি কিভাবে রেফার করব? স্পাইরালটা দেওয়া আছে? Spiral দেওয়া আছে?
Page 61.
Not that one, Lord. The spiral bound, Lord. The lower court document. Spiral bound documents আছে lower court.
Anyway, continue on the next day.
Lordship.
3:30.
Lordship. ওটা বার করে রেখে দেবেন না, ওই স্পাইরাল বাউন্ড দুটো আছে, ও উনি দেখিয়ে দেবেন।
Yes, learned advocates for the parties are present. Mr. Mukherjee, learned advocate for the appellant, submits but could not conclude his submissions. Let this matter appear on আচ্ছা 27 তারিখে দেখুন তো ইয়ে আছে কিনা। 27 তারিখ দুটোর সময় কোনো ম্যাটার আছে?
12টা বা 2টো।
28 তারিখে 28 তারিখে দুটোই হচ্ছে না, 3টের সময় 28 তারিখে।
28 তারিখই বাস। আরে বুধবার আজকে
আচ্ছা 27 তারিখে দেখুন। 27th you have some difficulty.
My girlfriend is not here. 28
Yes, 28th you will conclude.
Yes.
From your side.
Yes. Lord, kindly grant me, Lord, about 40 minutes of time, Lord. I will.
Anyway, I am keeping it at 3 p.m. on 28th.
As your lordship pleases, Lord.
Acha, let this matter appear on 28/1/2026 at 3 p.m.
Lordship. That is also, Lord, Mr. Chatterjee is there for the appellant and I am for the respondent.
That is also the Boshirat matter or Bunka matter?
Yes.
Oh, you are reverse. That is reverse.
Yes. But that is also fixed today at 3. Lord, that let it be also fixed on.
So same order, no. That
no.
Lord, let it retain its position. Acha, পরের ম্যাটারটা লিখে নিন তো. Let this matter appear on 28/1.
তাহলে 27 করে নিন। 27 দুটোই করো, 27 দুটোই করো। তুমি 40 মিনিট তারপরে আমি আরম্ভ করে দিই।
So let this matter, পরেরটা লিখুন, let this learned advocates are present. Let this matter appear on 28/1/2026 at 3 p.m. দুটোতেই 3 p.m. করে দেওয়া হয়েছে।
ঠিক আছে।
তুমি 40 মিনিট দিও, তারপর আমি না তোর তো আমারটাতে আগেরটাতে তো রিপ্লাই আছে।
So after Mr. Mukherjee concludes, you may take some other day and you may argue your case.
That makes sense, Lord. দুটোই
28 3 p.m. থাকছে।
That makes sense for both of us.
ভাই 27 তারিখে কোনো ঠিক ঠিকানা নেই, কে থাকবে না থাকবে, 26 তারিখে কিছু বেড়াতে যাবে, বুঝতে পারছিস না?
কালকে জাজমেন্ট আছে।